of the numbers of the constituencies fettered or altered or distorted the basic structure. The basic structure of the Constitution, my ladies, my lords, one of them is about representation. How does the increment of the constituency, so as to achieve equality and equity in representation, alter the basic structure? That we submit, my ladies, my lords, it is a judicial innovation that does not find any rest in our Constitution. My ladies, my lord, allow me to move on to my next point. And as I do so, my ladies, my lord, allow me to deal briefly with the question of public participation and its sitting in the circumstances of a popular initiative amendments. My ladies, my lords, the concept of public participation is intended to enhance participatory democracy, and as it enhances participatory democracy, it recognizes that it can interface with either parliament or the county assemblies. My ladies, my lords, Article 118 of the Constitution that creates public participation as an obligation for parliament, and Article 196 Clause 2B, which creates an obligation for public participation for the county assemblies, ought to be interpreted in a manner that allows it to achieve the purpose. The purpose of that the provisions, my ladies, my lords, is to make sure either parliament or the county assemblies do not arbitrarily abuse their powers when they are doing their normal legislations. But a fundamental question ought to be raised, whether or not a bill of this nature, a popular initiative seeking to amend a constitution, is a normal bill or normal legislative works of parliament or the county assemblies. Why should that then be the questions, my ladies, my lords? It should be the question so as to analyze whether the inputs of the public participation being collated and collected either by the county assemblies or the parliament will inform the bill. How did the judges of the Superior Court observe? They observed that neither parliament nor the county assemblies can alter the content and the context of the bill as submitted. So, my ladies, my lords, you realize that public participation in these processes should not have been elevated the way it was elevated by the justice of the Superior Court, simply because we are dealing with a sui generis situation. Sui generis, my ladies, my lords, in the sense that public participation collected and the views collected cannot alter the content. Why so, my ladies, my lords? Because the bill, whether domiciled in the parliament or domiciled in the county assemblies, is not owned by either of those organs. The bill is owned by the promoter. So can views collected ordinarily alter the content of a bill proposed? For example, I give an example. Could the county assembly of Kirinyaga say that we are now going to create an executive prime minister? Would that find a sitting in a bill of this nature? Yes, my lord, we submit no. How, my lord? The justice of the Superior Court ought to have applied the doctrine of sui generis while interpreting Article 118 and Article 196, which allows or which brings the concept of public participation. My ladies, my lords, allow me to move to the contradictions appearing in the judgment. To do so, my ladies, my lords, permit me to request you to go with me to paragraph 490 all the way to paragraph 496. And the fundamental question we'll be asking following my submissions is whether a judgment that contradicts itself in this manner is capable of being implemented. My ladies, my lords, at paragraph 490 of the judgment, the judges says that, and I read, it follows that the president has no power under the constitution as president to initiate changes to the constitution under article 256 of the constitution, since parliament is the only organ granted authority by the under the constitution. My ladies, my lords, the justice of the Superior Court observed that we need to have a holistic approach to the interpretation of this constitution. Therefore, on interpreting whether the president has the capacity to initiate amendments, we also ought to have borrowed leave in Article 119 of the Constitution. Permit me, my ladies, my lords, to make just some little reference to the same. My ladies, my lords, Article 119 says every person has a right to petition Parliament to consider any matter within its authority, including to enact, amend, or repeal any legislation. My ladies, my lords, they ought to have put into consideration these provisions, and as well put into consideration the provisions of Article 27. 27 provides that we all are equal before the law and we enjoy equal protection. What made the justice of the Superior Court to declothe the president of that right of equality before the law? Could it have been the intimidation of the status of the president? My ladies, my lords, we submit thus that insofar as this provision or this paragraph so appears, the justice of the Superior Court failed to apply the purposive rule in the interpretation.
Just a question, Mr. Ndegwa.
Yes, my ladies.
Does any legislation include the Constitution?
Well, lady, that might be jurisprudential and debatable, but yet we submit that it's a right that is available to a citizen. And since Article 12 creates those rights of a citizen. My lady, my lords, what did the justice of the Superior Court say? The same paragraph. The president, if he so wishes, can, however, through the office of the Attorney General, use parliamentary initiative to propose amendments to the Constitution. What an observation. Then they further say, under paragraph 496, permit me to read for purposes of clarity. In our view, in interpreting the Constitution, holistically, as we are enjoined to do so by Article 1 Clause 2, must be read together with Article 256 and 257 of the Constitution. When one considers these provisions together, the only reasonable conclusion is that Article 257 of the Constitution is reserved for situations where the promoters of the bill do not have recourse to the route contemplated under Article 256, which is the parliamentary initiative. Our view is in tandem with the historical genesis of the provisions we have set out here above. In other words, Article 257, my ladies, my lords, route is meant to be invoked by those who have no access to Article 256. Those who have access to Article 256 routes are therefore barred from purporting to invoke Article 257. They have said, my ladies, my lord, the president has no access to that route. Then the further says that Article 257 is only available for the person who has no ability to access parliament. They further says that under Article 94, my lady, my lord, that parliament is the only legislative organ. Are we making our president a toothless dog? Does the president continue to enjoy the rights enshrined in the Constitution, or is he declothed of those rights pursuant to taking of oath? My ladies, my lords, if you go again to paragraph 492. Again, allow me to read it. Beyond the text of the Constitution, there is another reason it is impermissible under our Constitution, in our view, to permit the President to initiate such amendments through popular initiative, and then sprint to the finishing lane away and receive it. Where in the facts before the court was it that the President was promoting a popular initiative process? They further say, my ladies, my lords, this is because Article 257 of the Constitution provides that if a bill to amend this Constitution proposes an amendment relating to a matter specified in Article 255, the President shall, before assenting the bill, request the IEBC to conduct within 90 days a national referendum to approve the bill. What an error and erroneous findings, my ladies, my lords. Article 257 clause 5 does not deal with the President. If you may read, my ladies, my lords, the specified article, my ladies, my lords, it provides that if Independent Electoral Commission is certified that the initiative meets the requirements of this article, the Commission shall submit the draft bill to each county assembly for consideration within 3 months. Could they have made erroneous finding because of the fixation they had with the whole notion of the President? Or was it just an apparent error on the face of record?
Counsel.
Yes, my lord.
What does sub-article 9 say?
Of the same?
Yes.
If Parliament passes the bill, it shall be submitted to the President for assent. That's correct, my lord. But yes, that is not what is captured in the judgment. The judgment speaks about the President taking the bill to the IEBC. We can only take what is recorded because it's a court of record, my lords.
So, he takes it to Parliament.
Yes, my lord.
And not to IEBC.
Yes, my lord.
What is the big difference as far as your argument is concerned?
Yes,
what is the big thing there? I mean, you're saying the President has no role at all, but you're saying, but the Constitution says he receives it and takes it to Parliament.
They are saying, my lords.
Just a moment. Yes. They say he receives it and takes it to the IEBC.
Yes, my lord. They are saying if an amendment details or touches on Article 255(1), the President, and of course that is emanating from, the amendment is emanating from 256. That is when the President is seized of this function. But insofar as we are dealing with an amendment under Article 257 as it is in these circumstances, it was erroneous for them to find that the President has a role to play. That's our submissions, my lord. My lords, as I sum up, the justice, if you look at paragraph 490 and you look at the finding Roman 3, the justice of the Superior Court declared that a declaration is hereby made that the President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257. A correct finding. But again, my ladies, my lords, the question is, what was the role of the President in the entire process? The role of the President in the entire process was detailed in Article 131 of the Constitution. What does it provide? That the President has the role of initiating national unity. Where do we get this national unity from, my ladies, my lords? We get it from Article 10. Article 10 provides the principles and values of national of governance. And the President, under Article 132, is mandated to make periodic reports to Parliament on how he has achieved the implementation of Article 10. But does Article 131 tell us the means, the modes, the manner, how the President is supposed to initiate the process of national unity? It doesn't. The law doesn't constrain and restrict the president. He is left to his discretion even to create a task force as such of the Building Bridges Initiative. Was it then possible that the court could then declare the Building Bridges Initiative unconstitutional? We must look at the objects and the purpose for which the Building Bridges was created. Among the fundamental purpose, my ladies, my lords.
Mr. Ndegwa, can you wind up?
Yes, my lord, I'm just waiting up. My ladies, my lords, the purpose for the creation of that organ was to enhance national unity. Can we fault the president for doing what is constitutionally his or what is constitutionally bestowed upon him? We submit no. My ladies, my lords, there ought to be equality of arms. When the matter of justice, Lady Justice, Deputy President of the Supreme Court, was brought before the court, she was treated with equality of arms. Why should we declare the president of his glory conferred upon him by the Constitution and clothe one organ with the other? We need equality of arms. Well, ladies, my lords, unless there is any clarification, I beg to rest my case and greatly thank the court for its time.
Thank you, Mr. Ndegwa.
My Lord, I have a preliminary request to make. Lord, there are substantive respondents totaling 8 in numbers. On the 2nd of June, when directions were given, we were given 2 hours each. My Lord, the speakers who are now on the floor did not speak before the High Court. In fact, they were not party to the directions that we took on time. My point is this. If the 8 of us will be given 2 hours, as we're entitled to, is it possible we'll conclude this hearing today or tomorrow? It is not. I therefore humbly request that we stick to the directions that were given. If they are supporting the appellants, let them just indicate they are supporting. Because it will be an anathema for the county government of Kirinyaga or Kiambu to come here and say they are supporting the president's position. That's just a humble request.
Thank you, Ms. Harvey. We have done with the respondents who are supporting the petition, and we are now moving to just hold on, council. Okay. We are now moving to now to the respondents who are opposing the appeal, and we have a total of about 16 who filed submissions, and it is not necessary that all of them address the court substantively. We are going to have a number of the appellants respondents address the court. Remember, when we are giving directions, we say that the court reserves the right to restrict time to avoid unnecessary repetition, because all the issues are cross-cutting. And once, for example, the first to fifth respondent, just as an example, have addressed us, the other respondents who are coming to make submissions in support of the first to fifth respondent's position need not take even half of the 2 hours. And that's why we said each side to organize themselves to determine who is going to address some of these thematic areas. We cannot possibly have each and every respondent having 2 hours. So that is the way we look at it. We have to finish this matter by tomorrow. We have sufficient time to do so. What's your name, counsel?
Your Lordship, my name is George Gilbert. I appear for the 71st respondent.
70?
71st.
Who is that?
Felista Wakesho. I filed my submissions. And I'm coming in support. Sorry, Your Lordship.
You come in?
I'm coming in support of the appellant.
Yes.
And I promise to this court that I will not even ask for the 20 or 30 minutes that my previous predecessor took. I am going to take maximum 10 minutes. Maximum.
Are you addressing us on a different issue, or you're basically highlighting an issue that is already on record?
I'm going to do a very simple highlighting of the Kivitu case of small relevance. Then I'm going to say something very small on the legislations that were decided that are required by the court for a referendum to proceed, making the referendum unconstitutional because of lack of legislation. I promise I will not take more than 10 minutes, Your Lordship.
Did you file submissions?
Yes, I did.
Can we see your submissions first?
They are dated the 23rd of June.
So, Mr. Gilbert?
Yes, Your Lordship.
We'll give you a maximum of 10 minutes. Start at 5.
I promise, Your Lordship. Now, Your Lordship, as I start my submissions, it is very important that I refer you to the judgment of the Superior Court. The copy I have is found in Attorney General Supplementary Record of Appeal, Volume 1A.
So your opening remark is that you're supporting the...
I am supporting the appeal in its entirety. I am supporting the submissions of all the parties who have come before me.
Okay.
And I associate myself fully.
All right, go now that with the substantive issue.
Now, Your Lordship, I refer you to court framing its issue, which is found at the page 5 of the judgment of the court, basically on the basic structure. In declaration number 2, the court is persuaded to consider chapter 1, chapter 2, chapter 4, chapter 9, and chapter 10 of the Constitution to be the relevant chapters that are part of the eternity clauses of the basic structure of the Constitution. Your Lordship, Article 255(1), A to J, if you look at it keenly, it actually encompasses all the chapters that are represented in that declaration that is sought. That is the position of the court. That was the position of the petitioners in the Superior Court. Your Lordship, it is true to say, as Professor Gidu said yesterday, that in many occasions the terms basic structure, eternity clauses, and unamendable clauses is used like interchangeably. If you look at 4 on the same page 5, it is the same chapter 1, 2, 4, and 9. We submit that the same chapters that are being talked about are the same chapters that appear in Article 255, 1A to J. Now, Your Lordship, what is so special about 1A to J of 255? It picks out of all the preceding 245 articles of the Constitution, the drafters picked special 10 of them, 10 articles, A to J, and said these are basic and core to the principles and values of this Constitution. The people of Kenya saw in their wisdom that 10 of all those articles are very important to this Constitution. What do they say about the 10? They say every other thing save for this 10, you must take it to a referendum. Your Lordship, if you go to 256 on the parliamentary initiative, 5A, they say that you can do anything, but when it comes back to the ones mentioned in 255A to J, go to a referendum. Your Lordship, go to 257.10, Article 257.10. They again say that if you want to touch on the 10 in A to J 255, go to a referendum. Your Lordship, I submit at this moment, there is a reason and a special and specific reason for those A to J in 255.1 being mentioned and say, for these ones, go to the referendum. Now, Your Lordship, I'm submitting that while the framers drafted and Kenyans passed that constitution, they very much understood the historical context of the country and the various attempts to amend the constitution, that they decided to say that these are special. Your Lordship, at this moment I pose the question: what is more important in a constitution than the Bill of Rights? What is more important than the independence of the judiciary? Those are the matters that the framers and the enactors of this constitution say, these are special, but they must go to a referendum. Your Lordship, my predecessor spoke about Kivuitu, and I hope you've not taken it off your desks. In the Kivuitu case, I want to specifically refer you to paragraph 158 and paragraph 159, specifically. Your Lordship, as I do that, it is important that I remind this court that Kivuitu is a three-judge bench of Justice Weldon Korir, Mumbi Gugi, and G.V. Odunga. The judgment was delivered by Justice Odunga.
Please remember your 4 minutes, counsel.
Yes, I know, Your Lordship. 158 says, we agree with the sentiments by Ringera J. in Joya 2, that an amendment that upsets the basic structure of the Constitution could not be effected by the Parliament without involving the people. That's what the three-judge bench says. Without involving the people is the important word. So the court realizes that according to it, it thinks those are the basic structures, and you must involve the people to be able to turn the issues in A to J, the matters. They must go to a referendum. 159, this is what the learned judges said. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in Joya 2 case was necessary. They are talking about the history of disrespect for the sanctity of the Constitution. Then they say, this may explain why the people of Kenya are aware of the frequent and frivolous amendments to the repealed constitutions provided in Article 255 of 210 Constitution, that the special core factors of A to J. Your Lordship, paragraph 162 of that judgment, they give an example of the independence of the judiciary. And they say as an example, 255(1)G provide for amendments relates to the independence of the judiciary, which should be approved by a referendum. So, Your Lordship, is it possible that what is being told to this court as a basic structure is not an amorphous organism put above the Constitution, that again, as we say, as statutes, we look up to the Constitution? Does the Constitution look up to another document that is amorphous, known as the basic structures? In fact, the judges in this court seem to suggest that what they would consider to be the basic structure of a constitution is actually the A to J in 255(1). And they say they can be amended as long as there is a referendum. That's what they say. And they say that specifically and expressly in the places that I've said. Your Lordship, when you retire, look at Kivuit well. Finally, when you're talking of the rules of if you want to amend, because the court made a finding that if you want to amend through a referendum, it is unconstitutional because their laws for referendum are not enacted. You also see chapter 16 of the Constitution, which talks about amendment, is one of the unique chapters that are not covered in Schedule 5 to be having what I would call constitutional dictates on legislative framework. The 5th schedule has listed very specifically the articles that must be enacted by the dictates of the Constitution: Environment and Land Act, Employment Labor Relations Court, National Land Commission. The one for legislation for the framework for referendum is not one of them, as IEBC submitted. However, it is provided for in section 49 of the Election Act. Your Lordships, 4 seconds back to you. Thank you for your time.
Thank you, Mr. Gilbert. First to fifth respondents, are you ready? Yes.
Now, good morning, my lord. My name is Mudomi Liankolu.
Good morning.
For the 76th respondent, there is a small housekeeping matter.
Sorry, Mr. Tiankolu, you are for?
The 76th respondent.
You are the one who is beginning the...
No, my lord, but I have the permission of the President of the Law Society to raise a small issue that is of concern for all the respondents.
Yes.
My lord, when we came for the case conference on 2nd, paragraph 8 of the order that you issued was to the effect that each of the respondents would have 2 hours, and each of the petitioners, or rather the appellants, would equally have 2 hours. And whereas up to that point there is no major issue, my lord, what has transpired so far is that we are hearing this case for the 3rd day.
Mr. Tiankolu, please let us not spend time on that.
Yes, my lord.
Wait a minute.
Yes.
Some of the respondents
Yes.
who have spoken here, we have given them 10 minutes.
Yes, my lord.
Not necessarily 2 hours, not necessarily 30 minutes, because they are not saying, they are not making any novel point that has not been made. And we are not going to sit beyond tomorrow. And so, we reserve the right to manage time in such a way that holding the scales of justice in an even manner to both sides, we hear you sufficiently. The sooner we start with the case, the better, so that if you are the one on the floor, if it is Mr. Harvey for the first, the 5th respondents, take your 2 hours, and then we'll determine what time to allocate to whoever comes after you, irrespective of what direction number 8 says, because in the last sentence we say that however the court shall be at liberty to limit the time allocated to avoid repetition. We knew that there were almost 81 respondents, but at the time there were not more than 5 or so who had made submissions. Why? Because the other parties, the other respondents, we assumed took the position that they were going either to support or, you know, they were taking more or less the same position as the one taken by either the appellants or the respondents. So Let us now go to the substance of the appeal.
My Lord, I beg you, grant me just 1 minute to make my point. We are not questioning the authority of the court to manage the time. What we are questioning is the evenness of how the time has played out in court, notwithstanding the directions. And the point we are making is, we scheduled 4 days for hearing this case. We, on the third day, part of it is still being spent hearing the appellant's case. Tomorrow we have scheduled some time to hear another appeal, which is also part of the appellant's case. It would follow, my Lord, clearly if we go that route, it would mean out of the 4 days we have scheduled, about 75% of that time, of the oral airtime in court, will have been spent by the appellant. Remembering also, the appellant still have another right of reply according to your directions. And it is in that context, my Lord, we are very humbly suggesting that even as we acknowledge the court must manage the time, we would very humbly plead with you, if they have spent, say, a cumulative of 20 hours, then give us, all of us, combined an equal amount of time, remembering they have even an extra time, because if we don't do that, my Lord, as we say, it cannot be said, at least not fairly, that we had an equal opportunity between the two sides to ventilate our respective cases. So all I'm saying, my Lord, I know we agreed we will finish this case, but for me I would suggest, if only for equality of arms, even if it means, my Lord, gives another extra day. We know the system has suffered because we have pulled all our judicial resources to handle this matter. But my Lord, I will remind you what we suggested on 2nd. This is the most important case of our lifetime. If we spend another 2 or even 3 extra days, fine, the backlog will still increase, but it will be time spent in a worthwhile manner. Otherwise, my Lord, if we proceed the way we are proceeding, our concern, and I'm speaking on behalf of all the respondents, is that when you accumulate the total time the appellants and their supporters have had, our time will be way, way shorter, and it's clearly not fair. Of course, my Lord, I leave it to the court.
Mr. Tiankolu, thank you. I've heard your point. And what we have said is this. First of all, I want you to remember that day 1, most of the morning was spent on the preliminary issue that we had to deal with. And yesterday, there was a time, almost half an hour, part of the afternoon, that we were not able to sit because of power interruptions. We have not come to the end of the session tomorrow. We have said, let us get going. If by the time we come to the end of the session tomorrow, we still find that there are substantial, substantive parties who must be heard on issues that have not been covered, we'll cross the bridge when we get there.
I'm guided, my Lord, so that I don't waste more time.
Let us now get to the matter.
And my President will take the podium, my Lord.
My Lord, the President of the Court of Appeal, my ladies and my lords, my name is Nelson Harvey. I appear together with Esther Angawa for the 1st to 5th respondents in the consolidated 4 appeals. And the respondents are Dr. David Ndii, Jerotich Say, James Gondi, Wanjiru Gikonyo, and Ikal Angele. On
Yes.
27th of August 2010, the people of Kenya promulgated a constitution. It was a perfect charter that defined the system of government. It created a pure presidential system with one executive, unitary. It created a minimum of 14 and a maximum of 22 cabinet secretaries. It created a parliament of 290 constituencies in the National Assembly. It also created a judiciary that was independent and accountable. There are those who have found fault in that constitution. They have proposed a total of 74 amendments. Within the stroke of the pen, which proposal dwarfs a total of 38 amendments effected on the Independence Constitution from 1963 to 1991. Our submissions are structured as follows. I will address the judicial authority over political actions and decisions, the legal underpinning for the basic structure, eternity, and amendable clauses doctrines, amendment and dismemberment, constituent power, popular initiative and constituent power, the President and constituent power, the effect of the Constitutional Amendment Bill 2020 on the basic structure. My colleague Esther Ngawa will address quorum of the IEBC, the role of IEBC in verification of signatures of supporters of a popular initiative, voter registration, public participation, referendum questions, and referendum law. The question on the basic structure was determined at paragraph 469.
Sorry, Mr. Avi, are you comfortable there or you'd want to use the podium?
I'm comfortable here because I want to have maximum use of my
Okay,
voice. Yes.
Thank you.
Thank you, my Lord. My Lord and my ladies, it was the finding of the High Court that the basic structure, eternity clauses and unamendable clauses is applicable in Kenya. To that extent, the High Court defined what the basic structure is. It stated that the basic structure is the constitutional core edifice or its essential features. The court further indicated that these two doctrines are identifiable from an examination of the history and the text of the Constitution itself. The court proceeded to say, and this we'll find at page 176 or paragraph 473 of the judgment, and I may quote, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable." So the doctrines are explicit. Sorry, they are implicit, they are not explicit. The court proceeded to indicate that insofar as the basic structure is concerned, an alteration is permissible, but only through the exercise of the constituent power. And the exercise of the constituent power was premised upon 4 sequential steps: civic education, public participation, debate, and a referendum as the ultimate process. Now, the question that arises, and which the appellants dwelt upon at length, was that the doctrine of constituent power is not textualized in the Constitution of Kenya and is inapplicable. May I take the court to the decision upon which this doctrine is domiciled in Kenya's jurisprudence, and this is the case of Njoya and 5 others versus the Attorney General. It appears in volume 2 of my bundle at page 642 all the way to page 728. And you will find at page 677, the anchoring of the constituent power. And this is what Justice Aaron Ringera said about the constituent power at page 677. Indeed, it is not expressly textualized by the Constitution, and of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela, out of an excessiveness of caution. Now, this doctrine did not originate with Justice Aaron Ringera. It is my submission that the doctrine permeates the entire history of democracy. You will find this doctrine elaborated by John Locke in the 2 Treatises of Government, volume 1 of my submissions, at page 247. This is how Locke defines constituent power. He defines constituent power as the power to form government. He proceeds to say constituent power connotes the subordination of the power of the Commonwealth. And the Commonwealth here refers to the civitas, civil government. Baron de Montesquieu, writing about the spirit of the laws, which you'll find at volume 1, in particular at page 318, identifies that constituent power.
Yes.
It is therefore my humble submission that constituent power is traced to antiquity insofar as democratic governance is concerned. It is not an emergent concept, it is not alien. May I conclude that particular part with what renowned professor of law Ben Nugweze states about constituent power. And you'll find this in volume 2 of my bundle, in particular at page 496. Page 496. This is what Nugweze states at page 496. The chapter is titled Presidentialism and Constituent Power. I will revert to the issue of the president and the constituent power. But in the concluding line of the paragraph, it is a power to constitute a frame of government for a community, and a constitution is the means by which this is done. In essence, therefore, it is the sovereignty. It is my humble submission that with those precise arguments based upon the law, we have founded the existence of the constituent power within the realm of constitutionalism. We need not look any further. Now, having identified the constituent power, we now proceed to consider the legal underpinning for the basic structure, eternity, and unamendable clauses and doctrine. Again, permit me to go back to the Njoya case, where the basic structure doctrine, in my humble submission, finds the first application in Kenya's constitutional jurisprudence. And this is what Justice Aaron Ringera said at page 688. Page 688. I've highlighted it. He says, all in all, I completely concur with the dicta in the Kasevenanda case that Parliament has no power to and cannot, in the guise or garb of amendment, either change the basic structures of the Constitution or abrogate and enact a new Constitution. What was the context in this matter? An entire abrogation of the Constitution was sought on the basis of Section 47 of the retired Constitution. The court said no. For you to alter that system of governance, you must go back to the constituent power. Speaking about the constituent power and the basic structure of the Constitution, and here you recall the question that was posed by Justice Kiage to Senior Counsel George Oraro: can the people of Kenya, through their majority, resolve to remove or abrogate Parliament? What was his answer? He said yes. Permit me to take you back in history. When is the pivotal moment in the history of the world when this was attempted? It was in 1933 by Adolf Hitler. And history records that of all the European leaders of that time, it is only Adolf Hitler who ascended to power with an overwhelming majority at the ballot. Now, let's see what Justice Aaron Ringera said about that issue. He proceeds. In my judgment, the framers of the Constitution could not have contemplated or intended such an absurdity, the removal of Parliament. And it will not be an answer to that concern to say, as was said by counsel for the second respondent, that the people can't change their Parliament. It is as simple as that. Now, let's domicile the basic structure in text. And I will take you back to Professor Nubweze, writing about presidentialism in Commonwealth of Africa, and still on the topic of the constituent power. And permit me to emphasize, when Nubweze writes, it is not a suggestion, it's not a concept. He indicates what the law is. And for those without the benefit of good learning, this is the point. If you go to your library, you will find the common law texts. For instance, we have Chiti on contract. Chiti writes the law. We have De Smith on constitutionalism. De Smith writes the law. We have Gower on company law. They write the law. So that when we find these postulations in the written works, they're not suggestions, they are the law. Now, we go back to page 496, where Nubweze talks about the basic structure. And in particular, you'll find this at page 500 to 501. 500, 501. If I may go there pretty fast. So we start with page 500 at the bottom where it starts as follows. A constitution is supposed to be a permanent charter which is to endure for ages to come and not to be lightly altered to meet the temporary expedience of political parties. And my lords and my ladies, as you pause there, let me take you back to the preamble of the Constitution of Kenya so that the significance of these points may sink. This is what the preamble says in introduction and in conclusion. We, the people of Kenya, then after enumerating all those recitals, says, adopt, enact, and give this Constitution to ourselves and to our future generation. Now, if any scholar of law or litigator were to ask you to locate the basic structure doctrine in the Constitution, then the answer will be, can you locate for me the doctrine of separation of powers, checks and balances, and independence of the judiciary? Now, we go on and see how Professor Nubweze has applied this basic structure to the Kenyan situation. And you will find this at page 526 of volume 2. 526, my lords and my ladies, 526. And I've highlighted at 526, but I'll proceed straight ahead to page 527. And the background is this. He has examined all amendments in the Independence Constitution at the time of his writing in 1973. And he has categorized them into two: the strict power of amendment and the power of repeal. And before I read what he has said, he concludes that there is a dichotomy between amendment and repealing. And what in actual fact happened to the Independence Constitution were not amendments, they were a repeal. This is what the renowned scholar of law says. This alternative method that was used initially in Kenya appears to be legally unimpeachable, the alternative method. Since the power to alter the Constitution was rather widely defined to include amendment, modification, or reenactment, with or without amendment or modification. And here is where we underline. However, applied to the Independence Constitution, but not to the Order in Council itself, it may be doubted whether the spirit of the amending power contemplated the destruction through the superimposition of a republican presidential form of the system of government instituted by the Constitution, namely monarchical parliamentary government. The so-called amendment, in fact, established a new constitution, and as such, should have been effected by the repeal of the existing Independence Constitution. He says this in 1973. Is he alone when he says this? No, he's not alone. He is joined by Justice Aaron Ringera many years later. And this is what Justice Aaron Ringera said, commencing from page 688 at the last paragraph. Before I leave this aspect of the matter, let me comment on the previous amendments to the Constitution of Kenya. Since independence in 1963, there have been 38 amendments to the Constitution. The most significant involve a change from dominion to republic status. The dominion was this: there was a governor general, and then there was a prime minister. There was the lower house and the upper house. What we commonly refer as to Madaraka Day is the day that we were given a prime minister. Within 6 months, by December 12th, what we commonly call Jamhuri Day, the Constitution was abrogated to eviscerate the dominion status and install a presidential system. Now, Ringera proceeds. Abolition of regionalism, what we now have as devolution, change from parliamentary to a presidential system of executive governance, etc. And this is how the learned judge, and he was indeed very learned, concludes. The effect of all those amendments was to substantially alter the Constitution. Substantially alter the Constitution. Some of them could not be described as anything other than an alteration of the basic structure or features of the Constitution. And they all passed without challenge in courts. My ladies and my lords, before Copernicus, before Columbus, there were many things about the earth that were not known. They are now known. The fact that we did not know something 10 years ago did not mean that we were foolish then. We were not wise. We've just grown wiser. He concludes, all I can say that is, in that respect, is that unfortunately or fortunately, the changes were not challenged in the courts, and so they are part of our Constitution. Now, fortunately for us, the 74 proposed eviscerations on our permanent charter were successfully challenged before the High Court. The High Court agreed with us. It is my humble request that you uphold the finding of the High Court on that issue. I will not...
Mr. Harvey.
My Lord.
Mr. Harvey.
My Lord.
I follow your argument, but I'm just wondering, the wisdom you speak of, past Njoya, the Njoya decision was in 2004, is it?
2004, Lord.
2004.
Yes.
He speaks very clearly about the place of the Constituent Assembly, right?
Yes.
Now, when you come to our Constitution, 2010, you have this chapter which talks about, I know you're looking at your watch, yeah, time. It lists those chapters that cannot be, or other sections, that cannot be amended without reference to the referendum. My question is this: why is it that we were able to incorporate the referendum, but we did not include the Constituent Assembly, which now the judges of the court below actually say is an important aspect in that process?
Yeah, my Lord, you're right. Your question is quite germane. And it is partly answered by Justice Ringera, and it is also answered by other scholars. And that is why Justice Ringera said, if we don't have a referendum in our law, it is implicit. Out of abundant caution, we have included the referendum. But, my Lord, let me trace the origin of the constituent power, because it is my humble submission that the constituent power is that which is in us. In French, it is called pouvoir constituant. It is almost traced back to God. It is in the category of what we call inalienable rights. For instance, I have the right to life. You may textualize it in the Bill of Rights. You may not textualize it in the Bill of Rights, but it is my right. Let me give you a more basic example. Childbirth must happen after 9 months. And there's a manner of happening of childbirth. If it is textualized, it is for the benefit of medical learning, but it doesn't change the mode. Have I answered your Lordship?
In a roundabout kind of way, you've attempted. Carry on.
Thank you. My Lord.
Mr. Harvey, just on the same issue, what's your view? Were the principles espoused by Ringera J in the Njoya matter realized by Kenya in the making of the Constitution of Kenya 2010?
They were realized to a certain extent. For instance, the referendum was textualized. The constituent power was not textualized. Public participation was also provided for in various aspects, commencing from Article 10, going to Article 118 and 119. But the premise upon which we seek to support the decision of the High Court is this. Even if they were not there, we are duty bound to follow them. There is an argument between Princess Anne and President Lyndon Johnson as to the efficacy of the Westminster model vis-a-vis the presidential system in the United States. And Anne told the president, if you are accustomed to mediocrity, you will find fault in perfection, referring to the English system of governance. Because in England, scholars will say that England does not have a written constitution. The fact of the matter that England does not have a constitution, that's the fact. What England has is demonstrable, perfected constitutionalism. So that these doctrines in here, and they apply whether or not they are textualized.
All right, move on.
Thank you, my Lord. My Lord, I will be doing an injustice on that topic if I did not acknowledge the works of Professor Richard Albert on the basic structure, which you will find I have extracted at page 1281. And Richard Albert says this, writing about how courts become supreme in defending the Constitution from unconstitutional amendment. He says that it is the duty of the court to defend democracy. Another writer whose mention requires immortalization for the purposes of these proceedings is Yaniv Rosnai, writing about populist constitutionalism and unconstitutional amendment doctrine. Again, he formulates the doctrine of constitutional capture. And because this is very relevant, permit me to cite and quote in brief what Rosenai states at page 1304. Of volume 4. He formulates the concept of constitutional capture by a populist regime or leader. And then he concludes at page 1307, the last paragraph. 1307. This is what Professor Rosnai states. Abusive constitutionalism becomes especially attractive 1307 at the bottom.
Yes, go on, we are with you.
Abusive constitutionalism becomes especially attractive with relatively flexible amendment processes controlled by a dominant party or the government. He proceeds, for example, what allowed the weakening checks and balances on the protection of rights in Hungary, effectively turning it into an illiberal state that fails to comply with minimum standards of constitutionalism. Here at home, and it is a pity that the few royal natives like Professor Githu Muigai and Professor Ben Sianya have not brought their works on this issue. Here at home...
Sorry, Council, what did you say?
I'm saying that the royal natives. You see, in England we have the lords, and here we have the professors when it comes to the law. So the royal natives, Professor Githu Muigai and Professor Ben Sianya, have not written on this issue. But one royal native has written on this issue. His name is Professor John Mutaha Kangu. Mutaha Kangu. And his book is titled Constitutional Law of Kenya and Devolution. And if you look at volume 4 at page 1276, 1276, this is what the good scholar of law says. The basic structure of the Kenyan Constitution should include the sovereignty of the people, the supremacy of the Constitution, the principle of sharing and devolution of power, democracy, rule of law, the Bill of Rights, especially the right to human dignity, separation of powers, and the independence of the judiciary. And then he concludes, just as the judges of the High Court concluded, that you cannot exhaustively enumerate which clauses in the Constitution to which to attach the basic structure, eternity clauses, or unamendability. He says, nonetheless, implied non-amendable aspects of the Constitution can be identified.
Council, flowing from that, I think the argument was made that if that be the case, the courts would have to be approached at every turn to determine what that comprises. What do you say to that?
My Lord, I listened to that submission with a lot of disappointment. The court need not be approached anytime the amendment is proposed. The reason is this. The court is the final arbiter of interpretations of the Constitution, but not the only one. Under Article 10, everybody is obliged to apply and interpret the law when formulating policy or making a decision. It will therefore be incumbent upon any initiator of an amendment initiative, be it Parliament or Wanjiku, to make that inquiry. And my Lord, this is fundamental because under Article 94 of the Constitution, Parliament's fundamental role is to protect the Constitution. And before I part from that point, this Parliament identified 3 areas of unconstitutional amendments in the bill. 1, the installation of an executive prefect in the judiciary in the name of ombudsman. 2, the manner of creation and allocation of boundaries. And 3, the want of a legal framework to enable amendment. But we nonetheless pass the bill as it is. Why? Because they failed to comply with Article 10 and Article 94 insofar as they obligate. And my Lord, it must sadden you that a legislator will come and tell you here that should we be coming to court every time we want to identify a basic structure? I think I've sufficiently answered that point.
It is not clear what the answer is to. So what is to happen if a proposal is made to amend? How is one to go about determining whether you are tampering with the basic structure or not? How do you make that determination?
My Lord, the determination is to be made by looking at the history of where we've come from. For instance, we have a pure presidential system of government. And upon it is anchored separation of powers and checks and balances. So that when you initiate that amendment, you need to look at the history of the people of Kenya in constitutional making. But should there be need for the issue to be determined in court, it will be determined when it has become germane. Like in our case, the issue was germane. It was not in the realm of conjecture. So that conundrum is one that should not prevail at this juncture. And because I want to leave my colleague with a clear 1 hour, let me quickly deal with the popular initiative and constituent power. Now, I will take you to volume 1 of my list and bundle. Volume 1, and here we are again referring to a scholar, a professor of law, Professor Albert Stern, Methods of State Constitutional Reform. And you will find the operative article at page 343. And I rely upon this decision, page 343, it's a written text, to indicate that popular initiative is not peculiar to Kenya. There is a colleague of mine who submitted that we are the only ones who have domiciled this doctrine.
Yes.
If we can look at page 343, this is what Professor Stern says. In America, it is called the Constitutional Initiative. And in paragraph 1, the last 2 lines, it is regarded as an expedient which may be utilized in situations where the legislature has failed to act. Substantially, the device amounts to a reservation by the people of the power to alter the basic law in their sovereign capacity without resort to the usual process of legislation through representation. And then Professor Stern proceeds to conclude when he's evaluating the efficacy of the constitutional initiative in the United States of America, and this is what he says at page 60. Page 60 at subtopic evaluation. As a technique of amending the state constitution, the initiative has distinct advantages and disadvantages. On the positive side, one of the most significant advantages of the constitutional initiative is its availability as a popular weapon to combat domination of legislative bodies. And then he concludes in that paragraph, not only is the constitutional initiative a device for avoiding stalemate in the legislature, but it also serves other useful purposes. If properly utilized, it may be a device for popular education of important public issues. An admission was made from this podium by none other than the Attorney General. They are pending before Parliament a total of 22 proposed amendments to the Constitution. One of my colleagues will deal with how the government...
Is it pending or attempts that have been made?
They're still in Parliament, 22, and we have enumerated them in our petition, 22. So therein lies the mischief. You've seen legislators speak here and seek to ascribe to themselves the title Wanjiku. A legislator can never be a Wanjiku. It's as simple as that. And I will conclude with that point when I'm talking about the president and the constituent power. And straight to the point, we'll start with the definitions at Article 260 of the Constitution. Who is a person? Who is a public officer? Who is a state officer? The moment you become president, you cease being a person. You become a state officer. And if there is any doubt as to how you are supposed to exercise yourself, then recourse can be made to 2 or 3 examples. We will start with Locke himself at page 250 of volume 1. Page 250 of volume 1, 250. And this is very imperative. This is very imperative, page 250. And I don't want to read the entire treatise, but if you look at, starting from paragraph 151 at the bottom, this is what Locke concludes about a state officer, the monarch, the executive, who ceases holding his office, a hallowed office. But when he quits his representation, this public will, the protection he enjoys, and acts by his own private will, he degrades himself. He degrades himself. And he cannot come here and complain through the Attorney General of being insulted. And is but a single private person without power and without will, the members owing no obedience but to the public will of the society. Locke proceeds to indicate that doing so amounts to tyranny. He has also defined tyranny at page 272 to 273. But before I examine what Nobweze states about the office of the president and whether or not he can exercise constituent power, permit me to premise the foundation from Article 131 itself. 131. Sub-article 2A and B. The president shall respect, uphold, and safeguard this constitution. There is no obligation of that kind on Wanjiku, Atieno, Nasmiu, Hadija, or Mwende. It goes at B, safeguard the sovereignty of the republic. There is no obligation on me to safeguard the sovereignty of the republic. Now, that is the office of the president. And we have seen what the sovereignty of the republic is. It is the constituent power. The president, like King David before him, cannot start taking the flock. The president, like King Edward VIII, must remain the president. If he wants to engage in the affairs of other lesser mortals, then he must abdicate. There are no two options to this matter. And to contextualize that quickly, we see what Professor Ben Nobweze says at page 462 of volume 1, sorry, of volume 2. 462 of volume 2. At page 462, writing about the extent and the reality of presidential power, Nobweze says the most striking feature of the presidency in Africa is its tremendous powers. Its formal powers exceed those of its American prototype, not in nature, but in extent. You now realize the lamentation of President Lyndon Johnson when they were having dinner with Princess Anne. And as he closes, this is what he says at page 483. The splendor, that is of the president, page 483, last paragraph. The splendor is indeed part of the social preeminence of African presidents. The splendor. Personifying the state, writes Arthur Lewis, they dress themselves up in uniforms, build themselves palaces, bring all other traffic to a standstill when they drive, hold fancy parades, and generally demand to be treated like Egyptian pharaohs. If Professor Nobwede and Arthur are lying, drive in the streets of Nairobi. The president is not a mere mortal, he is a superior mortal. Now, let me conclude with the effect of the Constitutional Amendment Bill on the basic structure, eternity, and unamendable clauses doctrines.
So, sorry, before you leave that, Mr. Harvey, so your submission, following from what you have said,
My Lord,
would therefore be that Articles 27, 38, among others,
yes,
cannot apply to the president?
the president cannot be party to a popular initiative.
No. I'm talking about Article 27, Article 38, among others.
My Lord, let me just go there. My Lord, they do not apply to the president. And I'll just give you one illustration. Let's look at Article 37. The right to assemble.
No, I'm talking about 27 and 38, among others. Can they apply to the president?
No, they don't apply to the president.
All right.
And the reason is simple, and it's in Article 37. Every person has the right, peacefully and unarmed, to assemble, to demonstrate. Imagine the president demonstrating or picketing.
Supposing, Harvey,
My Lord,
supposing the president is president on an independent, as an independent, I think that picture was presented here, and he has a parliament which is running rogue. Can he not make an appeal directly to the people, go to the people who elected him and demonstrate in the streets of Nairobi against that parliament?
a story is told today, I think it was told today by retired Justice Kwach or Dr. John Khamenei, that when there was a threat of toppling President Jomo Kenyatta's government, one Chief Justice joined the crowds to demonstrate in the streets of Nairobi, and it was ridiculous. But, my Lord, to contextualize what you're talking about, there is this documentary series, The Designate Survivor, the predicament of an independently elected president in the United States. It is a predicament. It may arise, it may not arise, but the fundamental proposition is this: Kenya is a multi-party democracy. You stand as no ball chance in hell winning the presidency in Kenya as an independent.
Supposing, because that was presented here, supposing Parliament doesn't listen to the President, Parliament has the majorities, and people in this country, people change, right?
Yes, my Lord.
If that happens, are you saying that the President cannot make a direct appeal to the people and join them in petitioning Parliament, for example?
No, my Lord, he cannot. If the president is such a predicament, he has to do which King Edward VIII did.
He has to resign.
He must abdicate and go and marry the American divorcee. It's as simple as that.
So what is the place of Article 1, Sub-Article 2 of the Constitution? Can Wanjiku speak through a state officer, even the president? Can Wanjiku present a request to a state officer say that this is my petition, this is my request. Can you, consider it and act on it?
But Lord, there is a reason why I refer to Professor Stan to create the conceptual framework of what in America is called the constitutional initiative.
Yes, and link it kindly to Article 1, Sub-Article 2, so that we make an informed decision regarding the question of sovereignty and the people exercising their power either directly or through their democratically elected representatives. Thank you.
Well, Lord, I agree. The question is quite appropriate. Under Sub-Article 2, the people can act through those two fora, directly or indirectly. When they do so indirectly, they do so through their representatives. When they do so directly, they do so in exercise of their constituent power. When all those other avenues, as Professor Stan says, have failed to yield results. But my Lord, because the...
Only when they have failed to yield results?
Yes, yes.
Okay.
And my Lord, perhaps now that you've asked that question, the answer that was given by Professor Nobweze may be apt here at page 496. Page 496 of volume 2. Yeah, he says, recalling again that the president under the presidential system in Commonwealth Africa is the organ that coordinates and therefore dominates the executive and legislative process of government, in particular, that it is he who, as executive, has and controls the legislative initiative. We ask the question whether his power in this behalf includes or should include constituent power. And when you progress with that chapter, Nobweze concludes affirmatively that the president can never exercise constituent power. And I may take you even further. Justice Wolfgang, who is also a professor of law in Germany, says this constituent power was not available to the monarch and is not available to the executive in a republican. No wonder, therefore, Germany had to entrench certain clauses because they couldn't entertain a repeat of what happened in 1933. Now, my lords and my lady, if you permit me to use these 13 minutes.
Yes, you can move on.
I want to interrogate the effects of the BBI bill on the basic structure. This is what the BBI bill has done: to destroy, to dismember, to eviscerate the basic structure of the Kenyan system. It has created an impure hybrid presidential and parliamentary system. And remember, Nobweze spoke about it concerning the change from dominion status to republic. This bill has domiciled the cabinet in the legislature, effectively obfuscating the functions of the executive and of the legislature. They may tell you we can't see separation of powers in the Constitution, but it's there. There is no separation of powers in what is intended. Thirdly, it has sought to interfere with the independence of the judiciary by installing an executive prefect in the name of Obczynski, aka Ombudsman, to perform functions allocated by the people of Kenya to the Judicial Service Commission. Parliament itself acknowledge this fault. My lords and my ladies, I would have wanted to speak much about this issue, but it's an issue that now requires retirement. It requires retirement, and for me to retire, I will quote two people, Nobweze and Justice Ewan Krigler. For Nobweze, I will quote what he says about the mixture of the presidential and parliamentary system, this time specific to Ghanaian founder, Dr. Nkrumah. This is what he says at page 624 of volume 2. 624, my lord. I will take you. Remember, when we were studying GHC and history, we were told many good things about Dr. Nkrumah. But you see, when you study the law, you will understand many other bad things about Dr. Nkrumah. And this is what happens. At page 624, at the tail end of that page, the linkage of the executive to the legislature was reinforced by the provisions requiring ministers to be drawn from the legislature. That is at page 624. However, neither the president nor his ministers were responsible to the legislature, and so there was no question of his being forced to resign because of an adverse vote. But Lord, I've spoken about the removal of the checks and balances. This is what I'm talking about. And this is what Nobweze concludes about the good doctor. The tendency to dictatorship, that is at page 625, the tendency to dictatorship of an arrangement which combines in a president full executive power and control of legislation is obvious. It is obvious. It is little wonder, therefore, that Dr. Nkrumah became a dictator under that constitution. And you know what Ghana had to go through for it to attain the stability that it enjoys now. As I conclude, let me again immortalize Justice Ewan Krigler so that he doesn't come back to Kenya when Kenyans, by their own will or through the propulsion of their leaders, decided that their destination must be hell. It should never happen. This is what Justice Ewan Krigler said at page 764, page 764. I'm referring to the report of the Independent Review Commission on the general election held in Kenya. This is what the good judge said.
What volume are you at?
That is volume 3. Volume 3.
Right.
Page 764.
Yes, move on.
The last two paragraphs. In order to start trying to prevent a recurrence of the tragic aftermath of the 2007 general elections, and this is where you underline, Kenyans, from president to peasant, will have to do an agonizing stock take of where their country stands. An agonizing stock take. From president to peasant, the pharaonic president who makes traffic stand, to the peasant, the holder, the bearer of the constituent power, pouvoir constituant. They will have to show their commitment to the rule of law and its equal applicability to all citizens, irrespective of economic, social, and political or any other belief. No, the solution does not merely lie in constitutional and legislative changes. The culture of impunity in Kenya needs a fix too. the relevant law enforcement institutions also need to do their jobs properly. IEBC must do its job. Parliament must do its job. We have done our job here. My lords, let the court do its job. I plead with you most fervently to dismiss the 4 appeals and affirm the decision made by the High Court. You owe these to the people of Kenya in tandem with the oath you took in accordance with the preamble. I beg to rest unless there is a question.
Your last exhortation seems to suggest that if we don't agree with you, we are not honoring our oath. But we could go either way. You realize that?
No, my lord, I just asked you to do your job. How you do it, you better qualify to know it.
Absolutely. Thank you.
I'm too junior to be able to do your job. Thank you.
Thank you, Mr. Harvey. Who comes after you? It's your colleague.
My co-counsel Esther Ngawa.
Yes, please.
She has the entire hour ahead of her.
Esther Ngawa, please.
Thank you, my lord. Good morning.
You have 35 minutes before we adjourn, then you come back to finish. I know you have an hour. So please proceed.
Thank you, my lord. Good morning, my lords and my ladies. My name is Esther Ngawa.
Yes.
On the first issue, on the quorum of the IEBC, I will not address the court substantively on the issues because our submissions cover them quite at length. However, there are a few points that I would like to bring to your attention following the submissions by the appellants on these issues. And the first, my lord, is on the distinction between composition and quorum of the IEBC. Indeed, His Lordship Justice Kiage did ask whether composition is the same as quorum, and we submit it is not. The composition of the IEBC is provided for under Article 250 sub-Article 1, alongside other constitutional commissions, as being a minimum of 3 and a maximum of 9. The specific composition of the IEBC was set at 7 by the IEBC Act, and the quorum, which is the number of commissioners required for it to undertake business, was set at 5 by paragraph 5, Schedule 2 of the IEBC Act. Now, my lords, the challenge by the Commission to the findings of the Superior Court on this issue is firstly based on an allegation that the Superior Court misdirected itself because there was no law requiring a quorum of 5. I would like to disabuse that notion, my lord, by looking specifically at the decision claimed to have declared as unconstitutional paragraph 5 of Schedule 2. That decision is Katiba Institute and others versus Attorney General at volume 1, page 154 to 173 of our bundle.
You see that page?
Page 154 to 173. That's the entirety of the decision.
Right.
But I would like, my lords, if you could go with me to page... If you could go with me to page 165. 165 of volume 1.
Yes.
And this is what the court says at paragraph 73 of that decision. The court says, prior to the impugned amendment, and this amendment, my lord, is the amendment introduced by the Elections Laws Amendment Act of 2017, which sought to reduce the quorum from 5 to 3. Prior to the impugned amendment, paragraph 5 of the second schedule to the Act provided that the quorum was 5, stating the quorum for the conduct of the business at a meeting of the Commission shall be at least 5 members of the Commission. After the amendment, the paragraph now provides that the quorum of the conduct of business at a meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3. Going down to paragraph 77 of that decision, this is what Justice Chacha Mwita said. Looking at the amendments and reading the Act as a whole, from the definition of chairperson, election of a member to exercise powers and functions of the chairperson, to the quorum of the Commission for purposes of meetings, it is obvious that these amendments have a negative effect and unconstitutional effect to the functioning of the Commission. To the last sentence in that paragraph, with the above in mind and considering the effect of implementing these amendments, I find and hold that the amendments to the IEBC Act are unconstitutional. It is the amendments that sought to reduce the quorum from 5 that were declared as unconstitutional. And my lord, the senior counsel, Professor Gidhu Muigai, sought to convince the court that the declaration related to the provision that required a quorum of 5 for the Commission. And the effect of the declaration of unconstitutionality was to completely remove that provision from the law. Now, my lord, before I take you to the consequences of declaration of unconstitutionality, let us assume that indeed Senior Counsel Gidhu Muigai was right on behalf of the Commission. Let us go to the case of Isaiah Biwott, which they quoted and faulted the Superior Court for ignoring For clarity, Katiba Institute was decided by Chacha Mwita on 6th of April 2018. 6th of April 2018.
It is a page?
Katiba Institute is the one I've just referred to.
No, I'm talking of the other one.
Biwott is 175 to 185 of that bundle. It comes right after Katiba Institute.
All right.
Now, in the judgment in Biwott, where the Commission was the first respondent, the first paragraph at page 175 says that, sorry, not the first paragraph, this is page 176, paragraph 2, it says the petitioner's case, which is supported by his affidavit sworn on 6th June 2018, 6th June 2018, after the decision of Justice Chacha Mwita on 6th April 2018. In Isaiah Biwott, the IEBC does not take the position that paragraph 5 of Schedule 2 is not law. Because in Isaiah Biwott, paragraph 5 of Schedule 2 prior to the amendment that was declared as unconstitutional is what is in issue. And my lord, if you go to page 181, if you go to paragraph 31 of the judgment in Isaiah Biwott, where the court is interrogating that issue, the court asks, is paragraph 5 of the second schedule of the IEBC Act unconstitutional for offending Article 251 and Article 248(2)(c) of the Constitution? The said paragraph provides that the quorum for the conduct of business at a meeting of the Commission shall be at least 5 members of the Commission. Finally, the court decides that the issue before it, which was to declare that the composition of the IEBC was unconstitutional and to find that the IEBC could not conduct upcoming by-elections, could not stand because by-elections did not require any decisions to be made by the Commission of a policy nature. My lord, the court, as rightly pointed out by, I believe, Justice Tuyot, was that that was not an issue here. The quorum of IEBC was not an issue in Isaiah Biwott. But what is key, my lord, is that
what did the judge say? Did the judge pronounce herself on the issue of constitutionality?
The judge did speak to the issue of constitutionality.
At which?
Of the composition of the Commission. It says, having considered the last page 185, having considered the petition, the Constitution and the law, and having regard to my findings and observations in the judgment, I find that the petition lacks merit and the order commends itself to me to dismiss it. When considering, in determining the constitutionality of the impugned provisions, the court says at paragraph 32, in determining the constitutionality of the impugned provisions, the rules of constitutional interpretation come into focus, providing the guidelines on the manner At paragraph 44 on page 184, this is what the court says. Having regard to the above decision, I do not find any inconsistency between the provision in paragraph 5 of the second schedule of the IEBC Act and Article 251 of the Constitution. Paragraph 5 required a quorum of 5.
What do you make of 43?
Paragraph 43.
Yes.
In the instant case, the petitioner prays for a declaration that the commission is illegal and unconstitutional for lack of quorum as a result of the resignations. The court finds that the alleged resignation was an issue that was neither here nor there and was not proved by any tangible evidence.
All right. So what's your bottom line, counsel, on that authority?
My bottom line is this, my lord, that the commission cannot say that that provision requiring a quorum of 5 does not exist today because of a declaration of unconstitutionality made by Justice Chacha Mwita on 6th of April 2018, when in fact the effect of that declaration was to nullify or void the provisions of the amendment and not what was amended. And that takes me to the effect or consequence of voidance. And I would like to cite...
Sorry, counsel, before you do that.
Yes, my lord.
It's clear from a reading of Isaiah Biwott
yes.
that the judge considered the decision of Judge Chacha Mwita in Katiba Institute,
yes.
right?
Yes.
And the bottom line in Isaiah Biwott was that even though there had been resignations, the IEBC could still conduct by-elections, etc.
Indeed, my lord, and I do not have an issue with that. And
All right.
the reason...
That's fine, that's fine. So my question is, if IEBC, through no fault of its own, has 3 commissioners, and the court has held without appeal that they can conduct business of by-elections, why can they not conduct the business of verifying signatures?
For this reason, my lord, the comfort that the judge had in allowing the commission to conduct business of by-elections was specifically because by-elections, and she said so in her judgment, by-elections are not a matter that the IEBC has to make, requires decisions of the commission on. They are regulated by legislation. In this case, and it was conceded before my lords and my ladies, that there is no legislation governing the collection, verification, and presentation of signatures for a popular initiative. So that comfort that the judge had in allowing the by-elections, the IEBC to conduct the by-elections, was based on the presence of legislation governing that. But in this case, there is none, and that is an issue that has been conceded before this court.
Counsel, do I understand you to submit that the formulation of the administrative guidelines that eventually were used or was used to verify is a question of policy?
Indeed, my lord. I will therefore, because I feel like the bench is on the same page with me, I will not take too much of your time. I will just lead you to Cooley Thomas, Professor Cooley Thomas, his treatise on the constitutional limitations which rest upon the legislative power of the states of the American Union. And this is at volume 1 from pages 2 to 36. And I will just request, my lords, that you look at the consequence of declaration of unconstitutionality at page 36. And this is what it says: and what is true of an act void in toto is true also as to any part of an act which is found to be unconstitutional, and which consequently is to be regarded as having never at any time been possessed of any legal force.
Sorry, that is page
36 of volume 1.
Thank you.
And I believe, my lord, that is why the judge and the parties were still adjudicating the quorum at 5 in Isaiah B. Watt long after the amendments had been declared unconstitutional by Judge Muita. I'll proceed, my lord, to the role of the IEBC in verification of signatures of supporters of a popular initiative, and paragraphs 710 to 763 of the judgment deal with this, includes the findings and the declarations 11, 12, and 17.
Counsel, can I request that you start on that? You have 15 more minutes to go. At this juncture, we take a 20 minutes break. You come and start on that issue.
Absolutely, my lord, I'm obliged.
Precisely after 20 minutes.
Much obliged.
And of course, tomorrow we expect the hearings to wind up before the 7-bench judge can proceed to peruse the evidence adduced by the lawyers before they can write their report. This is KBC Channel 1. We're giving you unrivaled coverage of the BBI appeal case hearing, and of course we are in the studio and of course in the company of lawyer Steve Mogaka. He has been with us, and of course he has been helping us to break down some of these legal jargons, and of course helping us with the proper interpretation of the law. Mogaka, thank you very much indeed for joining us. I mean, 3 days so far, tons of documents, being presented, and of course a very serious scenarios being created before the appellate judges. What conclusion would you have so far with what we have seen?
Thank you very much, and good morning, viewers. Really, what we are having is a play out of the unpacking of the decision of the 5-judge bench, and the appellants, who are the respondents in the High Court, concluded their case, and their business really was to poke as much holes as possible on the court of on the High Court judgment, and persuade the Court of Appeal to overturn the case. And they did a brilliant job, and just like I said yesterday, it is not time for those who are pro-appellants. It's not time yet to open champagne bottles, because it is
Thank you, my lords, my ladies. I proceed to the role of the IEBC in verification of signatures of supporters of the popular initiative. The Superior Court dealt at length with the question in paragraphs 710 to 763 of the judgment, and arising therefrom were declarations 6, 7, and 12.
Yes.
It is our submission, my lord, that it is necessary that there is a legislative framework for the collection, presentation, and verification of signatures over and above the provisions of Article 257, Sub-Article 4 of the Constitution. The appellants, particularly the Commission, faults the subordinate court on its findings on this issue.
Not the subordinate court.
Sorry, the Superior Court. My apologies.
Call it the High Court.
The High Court. Faults the High Court for finding that it was necessary that a legislation be in place before a referendum could be conducted. They rely on Article 257, Sub-Article 4, and wish that the court, after the comma, replaces the word which with the Independent Electoral and Boundaries Commission. And my lord, this is an attempt to run away from the first limb of that sub-article, which requires that in addition to the draft bill, the promoters of a popular initiative delivers supporting signatures. It was conceded, my lord, before you and my ladies, that the Commission does not have a repository of signatures. It was also conceded, my lord, that there is no legislative framework for collection, presentation, or verification of signatures. Hence, the attempt by the Commission to fill that lacuna by adopting the administrative procedures they did and which they say they used in the verification of signatures in relation to the bill impugned by the High Court. My Lords, my senior Eric Gumbo went at length to give the steps that the Commission took in verification, what they term as verification of signatures.
Is it verification of signatures or verification of voters, registered voters?
Our submission is that what is to be verified, my Lord, is the signatures belonging to the registered voters. You cannot have a signature without the signee. Now, what the law requires is that the person appending the signature, which is delivered together with a draft bill and called supporting signatures under Article 257(4), be registered voters. And so the Commission needs to undertake a process where it confirms whether what it has received as supporting signatures from the promoters are indeed signatures of registered voters. And our submission humbly is that if what the drafters of the Constitution intended was that the verification simply be that this name appears in the register of voters, it would have asked for a list of names of voters. It would not have asked for signatures. And indeed, my Lord Justice Kiage did ask what my senior counsel, Professor Gideon Miguel, was it? I think Senior Counsel Tenda Molo was referring to as a unique identifier. How would the IEBC know that that name, for instance, belongs to Esther Angawa, who has appended her signature in support of the bill? And Senior Eric Gumbo read to the court the definition of biometric data, which is what our law identifies in elections law as the unique identifier, biometric, defined as unique identifiers or attributes, including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA, and signatures. Of all the unique identifiers that would identify Esther Angawa to the Commission, it is only signatures that appears in 257(4) as a requirement to be handed to the Commission. It must be verified that those signatures belong to the people they are claimed to belong to. And it has been considered that there is no framework for such. In fact, Senior Gumbo went ahead as to say that to demand, he said that the court, the command of the court, and Senior Gumbo, if it wasn't you, please forgive me, it could have been any of the counsel for the appellants, my lords and my ladies. The submission was made that that command came from the High Court. It was not a command by the High Court. It is a command of the Constitution, Article 257(4) demands that. The appellants took umbrage with the fact that the Superior Court referred to its treatment of verification of signatures in the Okoa Kenya initiative, and more particularly that the High Court found it startling that the Commission was taking a completely different approach in this case on what it meant for them to verify signatures. My Lord, we urge this court to uphold the finding of the High Court on this question, and we urge you to be persuaded by what this court held in James Omingo Magara and Manson Onyongo Nyamoya and two others versus Manson Onyongo Nyamoya and two others, 2010. It's at volume 1, page 187 to 210. The particular paragraph being at 199. And this is what the court said, that the verification of voters, in this case, and I'm sure, my Lord, the presiding judge are well aware, this being an appeal against your decision when you were a judge of the High Court. And the argument was that the verification of voters is simply a matter of math, or the votes that were attained. And this court held that verification of voters or votes is not a basic exercise, but a matter that requires beyond simple arithmetic ascertainment. The commission submitted here that they ran the names through a program, the names. That is how they verified that the signatures they had received belonged to registered voters. And they attained the number 1 million, and that was enough. We humbly submit that the yardstick applied by this court in Omingo Magara must be the same yardstick, if not higher, for the verification of supporters of a popular initiative. Before I move to the next issue, my Lord.
So in precise terms,
yes.
How should that look like? How should that be done?
My Lord, let me begin by expressing my surprise that the commission can come and state that it does not have signatures or unique identifiers of voters in this country, especially because we have a biometric system of voter registration. We have a biometric system of voter registration, and one of the unique identifiers under the Act are signatures. It is incumbent upon the Commission, and more particularly because of the fact that taxpayers pay for the work of the Commission. Taxpayers pay for the biometric voter registration. It cannot lie in the Commission to come and admit that it does not have that which it says in the Act is a unique identifier when we have a biometric voter registration system.
So I understand you to then be saying that the Commission should then look at each signature, each signature of the 1 million, and then check that database and satisfy itself that each signature corresponds with that one.
Absolutely, my Lord.
If I could just follow, are you suggesting that registered voters who do not have signatures cannot participate, cannot be the support an initiative under Sabbatical 1 to make up the 1 million, so that those who do not have signatures cannot participate?
My Lord, it is not my suggestion. The Constitution demands that what is presented to the Commission are supporting signatures. If I do not have a signature as a voter, how would my signature end up in the list of supporting signatures to the popular initiative, unless I'm not understanding your flow, my Lord? You seem to ask what would happen to those without signatures. But the Constitution demands for supporting signatures. So if I do not have a signature, what will I be appending on to that supporting document?
What is the definition of a signature in law? You remember that in the Stanley Ngindo Matiba case versus Moi, that issue arose whether the petitioner who could not sign because he was paralyzed, whether he could present a petition. You remember that? Mm-hmm. So question is, a signature is required. What is a signature in law?
My Lord, I could write my name. It could be a scribble. It could be a thumbprint, if that is how that is what I have indicated to the Commission, is what identifies me as that voter. When you retire, my lords, please do consider Volume 1, page 343 to 361. Professor Albert Stam on methods of state constitutional reform addresses the same issue, more particularly at paragraph 347. Now, my Lord, before I move to voter registration, I think it is important that we look at the arguments given by the Commission for not being in a position to do what is demanded of it for lack of quorum. And particularly, my Lord, because this bill, the bill that was impugned by the Superior Court, is said to be an initiative of the people. And the Commission has come and said that even though it doesn't have quorum, it can still create the administrative procedures for this process, and the court should indulge it, because the question of the membership of the Commission is not its fault. And I believe, my Lord, you asked me, what if these things happening are not of the fault of the Commission? And my Lord, it is important to note that in Isaiah v. Watt, the judge said that he decried the late recruitment of commissioners, this lack of quorum being due to resignations. And I think it is important, my Lord, for us, just before I move from that point, so that we can understand what the court is being asked to do here when it is asked to overturn the findings of the High Court. The Commission, which concedes it has only 3 commissioners, is here saying it can still proceed to do what it needs to do despite the diminished membership. The Attorney General, who is the advisor of government, including the Commission, is also here saying the same thing. Let's overlook that issue because it's not the Commission's fault. The President, upon whom the responsibility to declare vacancies in the Commission is placed by Section 7 of the IEBC Act, is also here. Parliament, whose work is to oversight the executive, is also here, telling us to ignore the fact that there have been vacancies in the commission for more than 3 years and allow them to rely on their administrative procedures, which the commission conceded was supposed to be an internal issue and only came out because somebody wrote a letter asking, how are you going to do this verification? Never once has the commission, unless, because it hasn't made any submissions to that effect, stated what handicap there has been, why there has been no recruitment. Not once, not before the Superior Court and not here. Their submissions were purely ignore, we can still operate. In the country that we live in, my lords, it is important that we take notice of all those in power who ought to do their work within the precincts of the Constitution and fail to do so, but come here and expect the court to ignore all of that and assist them to continue down that road. Voter registration, my lord, paragraph 764 to 772 of the judgment deals with the issue of voter registration. Our submissions on this are very brief, my lord. Article 38, 3A and B of the Constitution gives any eligible Kenyan the right to vote. Article 82, 1C of the Constitution demands that voter registration be continuous. The Commission has submitted that voter registration has been continuous. Notwithstanding that the Gazette notice filed indicates that that is data as at 2019, 31st of December. My lord, young men and young women are still turning 18 after 31st of December 2019. Old men, young women, middle-aged are still dying after 2019, 31st of December. And the law demands, the Constitution demands voter registration be continuous. The Elections Act, and the Commission read this to us yesterday, Elections Act Section 5, subsection 1, provides that in compliance with the Constitution, registration of voters and the revision of the register of voters under this act shall be carried out at all times. Before I move to the except, my lord, we submit that there has been no evidence, not before the Superior Court and not before this court, that voter registration is going on or has gone on beyond the 2019, 31st of December.
I thought you were referred to an affidavit of Mr. Goa, where he deposed inter alia that there has been continuous registration, or you say that is not the case?
That affidavit, my lord, is it the affidavit that was introduced in reply to the
No, there was an affidavit. There was an affidavit that was filed in the High Court.
My lord, that affidavit did not provide actual data or information about evidence. I can come here and say that I have been reading 10 judgments a day as proposed by one of our seniors, Steve Ogola, but nobody can establish whether indeed I have been reading 10 judgments a day. Now, I would be more convinced by the Gazette notice that was brought into this court indicating the numbers of registered voters as at that time. And my lord, it is a matter of public notoriety, really, that there has been no voter registration.
All right, please move on.
My lord, the appellants have an issue and seek that this court overturns the finding of the High Court that no referendum should take place until there has been mass voter registration, nationwide voter registration. And they say so, this was their submission yesterday, that before the IEBC receives the notice or receives the bill from the president, that issue is not ripe. That was their submission. That they cannot begin voter registration en masse before they receive that notification and actually know that there is going to be a referendum. But what does 51A 1BA say, my lord? Registration of voters and revision of the register of voters under this act shall be carried out at all times except, when you go to BA, in the case of a referendum, between the date of the publication and the date of the referendum. Move with me, my lords, to section 49 of the same Elections Act, part 5 on referendum. And this is what it says at 49.6. Here I am assuming, my lords, I'm going with the argument that the commission made that these provisions are sufficient for governing the referendum, whether it be a constitutional referendum or an issue-based referendum. So move with me with that, and let's assume that we will apply these provisions to the constitutional amendment bill. And this is what it says: the commission shall conduct the referendum within 90 days of the publication of the question. Now, if the commission is to conduct a referendum within 90 days of the publication of the question, and 51BA states that no registration of voters can take place once the publication for the referendum is done, when really does the IEBC want all these Kenyans who are eligible to be registered as voters to be registered? What fault do they find in that holding by the High Court, that they must undertake voter registration before a referendum? They're saying they can only do that after they receive that bill from the president. Yet the very provisions that they wish to rely on, should there be need for a referendum, provide a 90-day timeline and the date of publication. It cannot be, my lord. That ground must fall. Public participation. The IEBC, among the other appellants, insisted that it is the plebiscite where the people participate. That is the heart of public participation in a popular initiative. We submit, my lord, and I will not extensively submit on what John Locke and Montesquieu provide in the Two Treaties and the Spirit of Laws, Volume 1, page 240 to 296 and 339. It is our submission, my Lord, that public participation is an incidence of a social contract, and it need not be textualized under 257 for it to be effectuated, or for the right to inhere upon the people. And my Lord, it is important that we look at the JLAC report and what it said about public participation. Volume 4 at page 1375 to 1559. That's the entire report. But on the question of public participation, this was the recommendation at paragraph 409 of the report at page 1495.
Yes.
I'll read it, my Lord. 409. There was need for Parliament to put in place a legislative framework on public participation at both the national and county levels of government.
Where are you, Council?
This is volume 4.
You say page 409, eh?
14, paragraph 409 of the report, but page 1495. 1495.
Yes. Please go on.
The Houses, further, in the absence of specific provisions under Article 257 of the Constitution, provisions should be included in the proposed law or in the standing orders of the Houses to provide for public participation in the processing of a constitutional amendment bill by popular initiative.
Yes.
My Lord, we move on to publication of that bill. Page 1501 at paragraph 437. It was observed that in order to avoid any question arising on the authenticity of a bill for an amendment of the Constitution by popular initiative during the processing of the bill at the various stages, a legislative framework ought to be provided for the publication of the bill. Paragraph 437, page 1501. My Lord, an amendment proposal through the parliamentary initiative cannot be placed before the House for the second reading within 90 days of its first reading. That is in the standing orders of Parliament. And that was the basis of the controversy in Parliament on whether or not, as Parliament considered the current BBI bill, whether or not that would apply, because the standing orders specifically term it to apply to a bill for amendment of the Constitution coming from Parliament. Now, my Lord, Justice Tuyot took concern with the shortened period of 5 days given to members of the public to confirm the list that had been put up by the IEBC of supporters of the initiative. The amendment bill went through Parliament within a month, all 3 readings. committee stage to the readings. It was submitted here that what is not expressly prohibited is allowed. To suggest that to protect the rule of law, to protect order, to protect the interests of the people, to allow them to participate in this process, we must write it down. Parliament proposed that there must be legislation to provide for these gaps that we all seem to see in the process of the popular initiative constitutional amendment. We submit that the Superior Court was proper to find that it was necessary for legislation to be put in place for collection of signatures, for verification of the same, for the same to be taken through public participation, for the people to be involved, not in 5 days or whimsically, depending on which body is making the decision at which time, but so that we all know, all of us, tomorrow, should Esther Angawa wish to amend Article 257 of the Constitution to ensure that we can no longer amend the Constitution, I should know that this is the way, these are the rules of the game. We find no fault in that decision, and we urge this court to uphold it. Finally, my Lord, I will deal very quickly on the question of referendum questions as I conclude, and I'll take you to Section 51 of the Elections Act, which was submitted to be sufficient. And this is what Section 51 says, subsection 1, where a referendum question requires a yes or no answer, persons intending to campaign for or against the referendum question shall form such national referendum committees and constituency referendum committees as are necessary. 2, where there is more than one referendum question, persons intending to campaign for or against each referendum question shall, on the application to the Commission, form one national referendum committee each and one committee each in every constituency for each referendum question. It is not in doubt that the wording in Article 257 is in singular a proposal for the amendment Now, let us assume the Commission will apply this section even where there are many questions, more than one question. A campaign must be for each referendum question. It is our submission that each amendment proposal in the bill even if the same were to be subjected to this section of the Elections Act, would have to be reduced to one referendum question for each amendment proposal. And my Lord, to help us understand why this is important, the need for one. I'll refer the court to volume 6 of our bundle. At from page 2141 to page 2160, is text by George Lutz speaking on Switzerland, which has been extensively cited, particularly by the BBI and Raila Odinga, the former Prime Minister, as the epitome of citizens' initiative. And my Lord, I refer you to page 2148. In the event I forget, my Lord, I would urge the court, and my ladies, I would urge the court to read this entire writing, piece of text, to understand the difference between the popular constitutional amendment in Switzerland and in Kenya. It's quite different from what the appellants wish the court to understand, but because of time, let me just take you straight to 214 at the second paragraph. That should be line 10. The first, under the Swiss constitution, it is their parliament to decide first whether an initiative is contrary to international law or does not comply with the requirements of consistency of form and of subject matter, and if the parliament finds so, then it invalidates that initiative. But these are the grounds that are given, and the reason why there must be a single issue in a single initiative. The first is the requirement of consistency of form and of subject matter, which means that there should not be more than a single issue in a single initiative. For example, one cannot combine an increase in taxes with a limitation on the number of foreigners in the same initiative, because a voter may be in favor of one but against the other, and as a consequence cannot really vote yes or no.
Yes, please proceed.
In conclusion, my lords and my ladies, we submit that the finding of the High Court, based on our Constitution and further supported by the Elections Act, the provisions of which the appellants submit should govern a referendum, demand that each amendment proposal must be in a separate referendum question. And on each referendum question, my lords and my ladies, the Elections Act demands formation of committees. And what are these committees for? Those committees are to campaign for or against at the national level.
So that was section what?
That was section 51.
51?
2.
Yeah, 51.2.
Yes. 51.2. One as well, my lord.
Yes.
And the point I wish to make there, my lord, is that we cannot take public discussion, public engagement, public participation outside this process to the ballots as proposed by the appellants. It cannot be an issue of the ballots. That is not where public participation inheres. That is the conclusion of a process that must involve people throughout. And that section 51 is important. That is what those committees are for those discussions. And I dare submit, my Lord, those committees seated together with people is an aspect of the Constituent Assembly as they sit and discuss those issues. This amendment, why do we need a prime minister? Why do we need that public participation, civic education? I think perhaps when we use big words, maybe we feel that we're not saying the same thing. When you're campaigning against something or campaigning for something, what would convince my senior Mutuma here? How would I convince him that this is the reason why you should vote for a prime minister? Or this is the reason why you should vote for the judiciary ombudsperson? We must have a discussion. Civic education may have been made a fancy affair by NGOs and civil society and all of that, but it is more than that. And if those provisions on the referendum submitted by the Commission should apply, I see no reason why the appellants have an issue with the findings of the Superior Court. None at all. I rest.
Thank you very much.
I will need the podium, my lord. I'll need the podium.
This is Mr. Mutuma
for the 19th, 20th, and 21st respondents.
19th, 20th, and 21st.
What are their names?
That's Tadu Alliance Party, Miruru Waweru, and Dr. Angela Mukari. Those are the petitioners in the High Court and the respondents in this matter.
All right. Thank you, Mr. Mutuma. Considering that Mr. Harvey and Mr. Ngawa have covered very good ground, how long do you require?
We've actually managed
without necessarily having to repeat the very same arguments. What is reasonable for you?
My president had donated the remaining 10 minutes, but we can stick to our 2 hours for 2 reasons, my lord.
No,
is that we will have to...
We will adopt the Kipkosgei formula. The 10 minutes were donated to the court.
Much obliged. I stand guided, my lord. So the 2 hours in the High Court, because it was submitted that the petitioners in the High Court brought before the court an issue that was not ripe for determination because there was no real dispute that the court was invited to address. We beg to differ, my lords and my ladies, in that we as the petitioners thought that there was a threat to this constitution. We invoked the jurisdiction of the High Court under Article 165 3D for both interpretation and enforcement of rights. Now, my lords, whereas the rest of us only have an obligation to defend this Constitution under Article 3, I do submit that you, my lords and my ladies, have a bigger role in that, apart from just having an obligation, the Constitution has given you authority to defend the Constitution. The rest of us do not have that authority. So it is my submission that we brought a real issue touching on a dispute on a threat to this Constitution. I do not see any other situation that the Constitution envisaged being defended than the instance case. In fact, I have always thought since the time we began these petitions that Article 3 was made for this particular purpose, not for any other purpose. Because this is the only time when the Constitution is directly under attack. I urge your lordships and my ladies to exercise your authority and defend that Constitution. On the issue of basic structure, my lord, I do agree that the words that have been used are in no doubt very fancy, technical in nature, that only legal scholars will understand what a basic structure is. My learned senior and President Harvey is so good with philosophy. I am not. So I will not go philosophical about it, my lord. But to me, I look at the basic structure and what comes into mind is changing an existing law. And there are only two ways of changing an existing law. And I'm using the word changing deliberately, not amending. There is a repeal and there is the amendment. But the two ways are acceptable legal ways of changing an existing law. Now, the effect of amending, and these are not my words, I went looking for the definition of amend at the Black's Law Dictionary, 9th edition. At page 94, it says, to amend is to make right, to correct, to rectify. Second meaning is to change the wording of, formally alter a statute, constitution, or motion by striking out, inserting, or substituting the old one. So when the Constitution talks about amending, that is what it has in mind. To make it right, to correct, to rectify. The second meaning, or rather the second way of changing a law, is to repeal a law. I went looking for the same definition in the same source, and this is how it defined repeal: to rescind, to abrogate an existing law by legislative act. Now the question is, does our Constitution envisage a repeal of itself? Or it only anticipates an amendment to itself? I have gone through the Constitution. There is no mention of a repeal. And there are two ways of repealing. One is by specific declaration in a new statute or main motion. That is, you have to declare it outright that we are repealing, we are doing away with it. That is express repeal. The second, as per the same dictionary, it is implied repeal. Repeal by irreconcilable conflict between the old law and the new law. So the question is, the BBI initiative, is it amending or repealing by implication? If it is repealing, there is no provision in our constitution of repealing, either expressly or by implication. And that's what we are talking about. If you do not find any clause in the constitution allowing a repeal, then you must say that we have our constitution for eternity. That is what it means, that we cannot repeal it. You cannot therefore go and seek refuge.
Sorry, come back on that statement. If there is no what?
My Lord, my summation is that
Yes.
there is no anticipation of a repeal in our constitution. It does not anticipate a situation whereby it will be replaced, either expressly or by implication. I have taken a lot of time to explain what that means, implication. So then it means the constitution as it is envisages a lifetime, an eternity. We cannot therefore go to Article 255 and seek to repeal the constitution either expressly or by implication. So if then the nature of the changes that are being brought are such that they bring about irreconcilable conflict between that what we have and that what we are bringing in, then we are repealing, we are not amending.
Council.
Yes.
I'm just wondering, you talked about fancy terminology,
Yes.
right?
Yes.
Do you think eternal and eternity clauses is a fancy thing? I mean, really, who knows about eternity? Nobody has ever been eternal. Are we saying the Constitution contemplates that it is perpetual? Would it have the same meaning as what you're calling eternal?
My Lord, what it means basically is that within the confines of our current constitution, we cannot repeal it. If we must go beyond 255, 256, and 257. And that is what the learned judges were saying in simple. Go back to the Njoya case. That you must now start looking at a process that is not envisaged under 255. Involve the people directly in a manner that they are amending, or rather they are creating a new document altogether. That is what I'm saying. So eternity means...
Your colleagues on the other side have a problem with eternity. I mean, you heard them. And I think that, well, I too would have a problem with eternity. What exactly does it mean? Would it be the same meaning if you called it something else other than eternity?
Yes, my Lord, I would say this. Eternity in this case means for as long as we have it, the document that we have. Beyond that, then, it's not eternity. And we must go beyond, if we must repeal, we cannot seek refuge under 255, because that is not an amendment, rather it's a repeal of the Constitution. I hope, my Lord, you've seen that I have a different approach on the basic structure so that I do not seem to repeat what...
Could I just follow that up?
Yes.
The definition you have given from Black's Law,
Yes.
does it accord with the definition in the Interpretation and General Provisions Act?
I must confess that I haven't looked at that, my Lord, but then if we must really understand what basic structure is, we must seek to get several and different definitions for us to really understand. So the question would be, do we have an implied way of repealing rather than the express one? If the answer is yes, then we must settle that 255 is not the answer when you seek to repeal the Constitution, either expressly or by implication. My Lord, let me move to...
Mr. Mutumwa?
Yes.
If I get you right, what you're saying is that our Constitution provides for the amendment of the Constitution, but it does not provide for repeal.
Correct, my lady.
So we have to look outside this Constitution if we wanted to repeal it.
That is my argument, my lady, so that If, for example, today we got tired of this constitution that is eternal, we have a mechanism, but it cannot be found under 255 or in any of the provisions under this constitution. Just like we did prior to 2010, we could not have gone back to the constitution. We had to go outside that and replace the existing norm with another norm. That is my argument. If I may then move to the issue of popular initiative. My lords and my ladies, Article 1.1 of the Constitution talks about sovereign power, not just sovereign power, but all sovereign power belonging to the people. This is power that can be exercised directly or indirectly, and we have heard that story many times. But the question that has not been said, rather the question that has not been asked, what is this power that the people must exercise, or that the power that belongs to them? I submit that there are only three powers capable of being exercised, directly or indirectly. One is the executive power, judicial authority, and legislative authority. Those powers belong to the people. They can be exercised directly or indirectly. Now, the people donate those powers to their democratically elected representatives, and they are exercised on their behalf. But they still reserve the right to exercise them directly. Now, for the purposes of this appeal, I'll not talk about executive power or judicial authority in terms of powers envisaged under Article 1.1. I'll talk about legislative authority. So we are in agreement that indeed that power belongs to Wanjiku, the people. So is there a place in the Constitution where the Constitution envisages that Wanjiku will exercise legislative power directly? That is the question. And before I move to that, to the answer to that question,
and as you do so,
yes, Your Lordship.
Can you attempt to define the people? Are you included in the people?
Indeed, my Lord, I am the people. We are the people.
Am I included in the people?
You are.
So what is your definition of the people?
The people is, in fact, the Constitution does not talk about the people. It talks about the people of Kenya.
Yes.
Right? So if we are in Kenya, citizens of Kenya, living in Kenya, we are the people. But then, my Lord, when we, the people, collectively donate our powers to you individually, to exercise on our behalf, you cease to be the people. So that now you're exercising powers on our behalf. So you cannot, unless you relinquish that power that we've given unto you, then you come back to our fold, and now you remain as the people. So we give you authority as the judiciary. We give you authority as the legislature. We give you authority as the executive. So you cease at that moment being just the people, but we elevate you above the people. That is what. So there is a moral higher ground for the person to whom authority is donated.
Can I speak about an issue that affects me as an individual and not as a judge?
Indeed, my Lord. And we have seen that happen time and again. That once you leave the bench and you walk home, you do not walk home as a judge. You do not exercise your powers as a judicial officer to your employees, to your neighbors. You remain an individual. So you will have to tell us, and let me just give an analogy, my Lord. The government and the people are gracious enough to facilitate the movements of the people we donate power to. Government vehicles. When you're on official duty, there is a flag to your vehicle. When you're not, I have seen judicial officers covering that part, symbolizing that now, this is not me the judge, this is me the person. So you must somehow put that crown down and now become the person. It must be known that the person speaking now is not the person to whom authority has been donated or not. That is my argument.
Thank you.
So, my lord, then, as the Constitution envisaged that the people will exercise judicial authority, or rather legislative authority, the answer is yes. The people to whom legislative authority has been donated is the legislature, parliament, not the executive, not the judiciary. So the judiciary cannot purport to exercise legislative authority, neither can it purport to exercise executive authority, because that has not been donated to you. Neither can the executive purport to do that. And to answer the question that was posed by the bench, in a situation where the president feels he does not have the majority in parliament and feels somehow crippled, I would then suggest that is actually the essence of separation of power. Because the president is not in the business of legislating. That is the business of legislature. So he should not even be seen to bulldoze parliament, because that is not his business. So then, the people, how do they exercise legislative authority? Let's go to the preamble of our Constitution. And my president read that part, but there is another angle I want to bring into it. At the end, it says, we the people, having talked about a lot of things, exercising our sovereign and inalienable right to determine the form of governance to our country, and having participated fully in the making of this Constitution, participated fully, not partially, not indirectly, but fully. There are two words that go after, my lords and my ladies. Adopt, then immediately enact. They do not just adopt, they adopt that which they have enacted. So the key word there, and I want you to take note of the arrangement, is adopt coming after enacting. So then, at the preamble, we are clear that we, the people, have legislative authority, and we can exercise that power directly by fully participating in the constitution-making process. Let us jump to the elephant in the room, 255, and see what it says. It says, and I read, a proposed amendment to this Constitution shall be enacted. The word again appears, enacted, in accordance with Article 256 and 257. And then what happens? Approved. The preamble talks about adopting after enacting. 255 talks about enacting, then approving by way of a referendum. So let's not confuse the two terms. You enact, you adopt, you approve. Rather, you approve, then you adopt. That is the sequence. That is found, again, under 255(3), that an amendment to this Constitution that does not relate to a matter specified in Clause 1, again, shall be enacted, not approved, not adopted, but enacted. So the instructive word is enact. Either by Parliament, and Article 256, or by the people and Parliament, in accordance with Article 257. So who should be involved in the process of enacting? the Constitution for the purposes of Article 255B, it is the people. In exercise of their legislative powers directly, without involving any other person, without donating, they have receded their authority given to the legislature, and they're exercising that directly. So it is enactment, then approval by way of a referendum. What the appellants have been telling us is that our role as the people is only to be seen at the approval stage, that is the referendum. So then the question is, who has enacted this law? And 257 is the only instance in this whole constitution where the people have reserved the right to enact, to legislate. There is no other. So could it then be said that under Article 1, that authority was pronounced in vain, that we have legislative power but in vain? We must be seen to exercise that authority at this juncture, 257. Let me go to Article 257, and again there has been a misunderstanding of 257 in my own understanding, that the initiative begins with their million signatures. A term is different. The term that is used there is very different. An amendment to this constitution may be proposed, not enacted, but proposed by a popular initiative signed by at least 1 million registered voters. So what they are proposing here is making it formal, what they have already enacted, what they have already created under the sovereign power. Because even in Parliament, a bill is presented for reading, a bill that has already been enacted by Parliament. Then it is read. A proposal is put on the table. So the 1 million signatures is not for the purposes of creating, it is for the purposes of officiating a process that they have already begun as the people. So when then the appellants come here and tell you that it doesn't matter where those proposals come from, that you only need to gather 1 million signatures and present, they are dead wrong. They must be told that. We submit that a popular initiative must begin with the people by way of enacting, then officiated by way of proposing, or rather endorsing, by 1 million signatures.
Who will do the enacting?
The people, my lord.
Tell us the methodology.
And that is why basic structure comes in. That you must have involved the people as per the preamble, fully participating in the process of enacting that document.
Mr. Mutuma, I'm not saying you are wrong. I want to understand, minus the legislature, without the legislature, how will the people enact?
Indeed, my lord. And that is why, under 256(4), it says that what can be presented to IEBC could be in form of general suggestions, then converted into a bill. The people are powerful. The people are capable of drafting. In fact, if we were to go by the assertions of the appellants, this was drafted by Dennis Waweru and Junet Mohammed, the two of them. That is what they want us to agree. So that it should not be a problem for us to enact a law. In any case, this was done by two individuals. That is what they're telling us. So we have the capability.
Mr. Mutuma, I don't think we were told Junet Mohammed and Waweru enacted, but that they were the promoters.
I agree, but we have not been told who the enactors are, and that is even our greater problem. And that's why, subsequently, we will show that the executive was involved all through. So, but my point is this. It will not be difficult for the people to enact. Because we the people are lawyers. We the people are judges. We the people are drafters of the Constitution. As long as they are fully involved in the process, because that is it, enacting.
Did the legislature play any part in the birthing of this Constitution?
The current one, yes, my lord. But in a popular initiative, their role is merely ceremonial. They do not in any way involve. But there is a point I'm trying to make here, that at that juncture of enacting, it must be seen to be a process by the people.
All right,
and I do not doubt the people's
on,
capabilities of drafting a bill.
Move on, Council.
Yes. So my lord, then, it is not in doubt that a popular initiative can only be enacted by the people, proposed to IEBC by the people, and approved finally at the referendum by the people.
Mr. Mutuma, I think you need to get that sequence right. According to you, the sequence is enactment, followed by proposal, followed by?
By approval. And approval is in 3 stages. At the county assemblies, there is a threshold. At the National Assembly, at the Senate, then finally at the ballot by the people. Those are the instances.
Isn't enacted really an all-encompassing term that refers to that entire process, from the moment there was a proposal, preparation of a bill, approval, so that in the end, when it's done, you can say it has been enacted. But if you say that you begin with enactment, then a proposal, what form does enactment take?
According to the definition of an enactment, again, I'll go back to the Black's Law Dictionary, the same definition, is to make law, to pass law.
Exactly, and
yes.
it is not enacted until it has come into being. But in your sequencing, you say it is enactment followed by proposal and approval, and that is getting me a bit confused.
A proper reading, my lord, of Article 255 talks about those 2 processes, enactment and then approval. So it cannot then be that enactment is the final product when the Constitution talks about enactment by Parliament and approval by way of a referendum. So there is a distinction right from 255 that you enact, then you send that which you have enacted for approval by way of a referendum.
But if it is in accordance with 256, and 256 talks of a bill, are you saying surely the legislature is not the one that is going to formulate this bill?
My lord,
because 255 says in accordance with 256. And 256 says a bill to amend this Constitution may be introduced in either House of Parliament.
Yes, under 256, my lord, Parliament has the right to enact.
No, I'm saying
yes.
255 reads, a proposed amendment to this Constitution shall be enacted in accordance with Article 256 or 257. And 256 talks of a bill to amend this Constitution may be introduced in either House of Parliament.
My understanding, my lord, of the role of Parliament at 255 3B is that at the end of it all, we will see Parliament either approving, then it becomes the final product, if it does not involve the protected clauses under 255, then they will now enact and approve at that juncture.
All right.
Yes.
Please move on.
Thank you.
Before you move on, now, since your stand is you are faulting the process, and that is why we are all engaged here. just for
So,
yeah, for me to understand. Yeah, for me to understand you better and move on the same wavelength in a minute or in a second, according to you, and you are going to explain to us what should have been the correct procedure in line with the definitions that you have given us, just for me to understand so that we move together.
What I was trying to establish, because that was the appellant's case, is that it does not matter where the promoter of the popular initiative gets the proposals from. That was my argument. My argument is that a promoter from nowhere does not become the initiator of a popular initiative merely because they have brought 1 million signatures. So they must be able to establish that the people have been involved fully in that process. And now I am moving to my second and last part. I see I only have 29 minutes. My Lord, then, with that understanding in mind, who then initiated this process? Because we have seen the executive cannot initiate because they have not been given legislative authority. That has not been donated to them. Parliament has also not been given authority to legislate under 257. Theirs has been reserved under 256. Then, where did we get this impugned constitutional amendment from? My Lord, the appellants have come before this court. They have advanced 3 theories, and I call them theories because they come from different appellants. The first theory is that this was an initiative by one Dennis Waweru and Junet Mohammed. That has been submitted. Now I find that to be, for lack of better terms, taking us for a ride. So instead of them coming here and owning up, coming out clear to tell us who the promoter initiator was, they have told us these 2 individuals promoted this initiative. The second theory is that it is not Dennis Waweru and Junet Mohammed in their personal capacity, but an entity known as BBI National Secretariat. The other theory that has been brought to your attention is that it could be, and I'm using the word very carefully, because that came out, though not very expressly, that's why I'm calling it a theory. It could be the president, either in his official capacity, as a symbol of national unity under Article 130, 131, and there is nothing prevented him from actually initiating a popular initiative, or on the other hand, it is the president, but not in his official capacity, but as a person who also enjoys rights under the Constitution. My lords and my ladies, the impugned amendment process must be viewed as a direct product of the handshake that we all know about. Those facts are not in dispute. At the steps of Harambee House, between His Excellency the President in his official capacity and Right Honorable Raila Amolo Odinga. We submit that though the handshake was packaged as an initiative to promote national unity, cohesion, fostering cohesion and bringing about unity, it was a Trojan horse. A Trojan horse packaged as a unity package by the state to use executive powers to amend the Constitution. And let me pause there and address an issue that I know I might forget to. When the handshake happened, my client, Third Alliance, proceeded to the High Court and filed petition 451 of 2018. You have been told that you declare the petitions in the High Court res judicata on account of that petition, 451 of 2018. Now, after the handshake, my clients were apprehensive that this is actually a Trojan horse. And they moved to the High Court and sought for declarations to declare the establishment of the task force as illegal. We filed that matter in 2018. The declarations we sought were only to declare the establishment of the BBI task force as unconstitutionally constituted and disregard its report. At the time, suffice to note that we do not have the BBI steering committee. Justice Mativo looked at the terms of reference of the task force and found nothing wrong with the terms of reference, and that the president was within his powers under Article 130, 131 to foster national unity and establish a task force, but only to the extent that it was going to advise him on policy issues. You will note from that Gazette notice that there is nothing mentioning amendment of a constitution. So we agreed with Justice Mativo 100%. That's why we never appealed. So to say that this matter is res judicata is not correct. The parties were different. The principal party there was the Building Bridges Task Force. It is not a party in these proceedings. The issues were different. It did not touch on the amendment of the Constitution. So it cannot be said that it is res judicata. Now, was it Dennis Waweru that initiated this process? In our petition that we filed in the High Court, we made a description of the parties that we sued. Because the first party that we sued was the Building Bridges Steering Committee that had been established by way of a Gazette notice dated 10th of January 2020. Now, we also sued the BBI National Secretariat, and this is how we defined them. The first respondent, and I'm looking at pages 1477 of the AG's Record of Appeal, Volume 4, that the petitioners, that the first respondent is the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force established by the President of the Republic of Kenya by way of a Gazette notice dated 10th of January 2020. The second respondent in our petition was the BBI National Secretariat, which we defined as follows: as an administrative department of the first respondent. The said secretariat, in our own description, is co-chaired by the following individuals. One, Honorable Junet Mohammed, who is a member of National Assembly under the ODM ticket, and Honorable Dennis Waweru of the Jubilee Party. That is how we describe them. Now, after being sued and served, the first and second respondents instructed an advocate, Messrs. Paul Mwangi and Company Advocates, via a notice of appointment dated 10th of December 2020. It's to be found at page 1741 of the Attorney General's response, Record of Appeal, volume 5. He entered appearance for the respondents, who is the BBI Steering Committee and the Secretariat, not Junet Mohammed, not Dennis Waweru. Now, according to the submissions filed by the appellants at page 37, this is the BBI's submissions. They fault the High Court for making the following orders. That it is evident from paragraph 529 of the impugned judgment, the learned judges fundamentally conflated the roles of the task force and the steering committee on the one hand with that of Honorable Junet Mohammed and Dennis Waweru. This is very important. Trading in the name and style of BBI National Secretariat. So what they are telling us is that BBI National Secretariat is a business entity owned by Junet Mohammed and Dennis Waweru. That is in their submissions. Let us contradict what they said in their response in the High Court. They filed a response to our petition. That replying affidavit is to be found at pages 1755, again, of volume 5 of the AG's Record of Appeal. This is very interesting, my lords. Dennis Waweru swears an affidavit dated February 5th. At paragraph 1, he says, I am the co-chairperson of the Building Bridges to a United Kenya National Secretariat, and my co-chairperson being the Honorable Mohammed Junet, together with Honorable Junet Mohammed, duly authorized to swear this affidavit on behalf of my co-chairperson and on behalf of BBI, Honorable Raila Amolo Odinga, the respondents in this case. My point is, the respondents in that case was not Junet Mohammed, was not Dennis Waweru. We sued them in their capacity as officials of BBI National Secretariat. They never filed a single notice of protest to that description. They in fact confirmed our position by way of an affidavit that they are co-chairperson of that entity. At paragraph 3, they say, describing now the respondents, rather the BBI initiative, that the Building Bridges to a United Kenya was created and mandated with the task of initiating constitutional amendment process and unifying Kenyans, among other functions. They confirm it in their own pleadings.
So what is your bottom line, Counsel?
My bottom line,
following that argument.
My bottom line,
yes,
my lord,
yes,
is that Dennis Waweru, Junet Mohammed cannot be said at this juncture to be the initiators of this process. It must be seen as an initiation of the BBI National Secretariat, which is an administrative body of the BBI Building Bridges Steering Committee. That is my point.
All right.
And to cement that fact, because it has been said, and I had my learned friend, Senior Counsel Otiende Amolo, saying that as at 30th of June 2020, the BBI Steering committee was not in existence. That is what they said. It is also captured in their submissions. As of 16th of October 2020, months after 30th of June 2020, when it is said that the BBI task force was not in existence, that is when the BBI steering committee was handing over the report to the president at Kisii State Lodge. We annexed that in our affidavits. In their forward, dated 16th October 2020, they say that, and it is addressed to Your Excellency the President of the Republic of Kenya, that you appointed this steering committee by Gazette notice published on 30th January 2020, and they state the terms of reference. I do not want to rehash them. But at the end, what do they present to the President on 16th of October 2020, when impugned, and that is now the gist of this case. It is in this committee, this report rather, where the impugned BBI, that is the Constitution Amendment Bill of 2020, was attached to that report. That evidence again was produced. I invite you to look at the affidavit of Mirodu Waweru, sworn on 3rd of December 2020. That report is signed by all the members, in the next page, of the steering committee appointed by the President, including my good friend, Mr. Paul Mwangi. His signature is here as a joint secretary. So they are the people who drafted, that's my point, who enacted this piece of legislation, using executive authority by way of a Gazette notice. That is the point that I was interested in making. In fact, looking at the bill itself, it does not in any way mention the so-called promoters. At volume 7 of the AG's record of appeal at page 2534, that bill, the Constitution of Kenya Amendment Bill 2020, dated 25th November 2020, was number 1, most importantly, printed by the government printer. At the end of it all, it is said the promoters at the end, to be found at page 2576, are the following: Building Bridges Initiative, stroke promoter. It is there in that bill. So when then the appellants come here, tell us what they did not tell the High Court, that they were indeed, that indeed it was promoted by Dennis Wawere and Junet Mohammed, it is an outright lie. It cannot be allowed to pass. Parties are bound by their own pleadings. My lords, having established that indeed it was the executive that initiated this process, and having also established that the executive is not allowed to initiate a popular initiative because that power has not been donated to them, I submit that the impugned bill is unconstitutional. It is not a popular initiative. It is a presidential initiative. And to go back to the question that Your Lordship, the President of the Court of Appeal, asked me, whether once we donate once we donate sovereign power to you, do you still have individual rights? Like the President would want us to argue, to agree rather, yes. And like I said, you must avoid declothe yourself of executive authority, then become a citizen. I'll give you an example that happened with this same executive, Your Lordship. In 2014, our president was facing a personal case at The Hague. When he was leaving for that case, which was his personal matter to attend to, he did the right thing. And I believe, under the advice of Emeritus, AG then, Professor Githu Muigai, he handed over power to the Deputy President. appointed him as the acting president, went to The Hague as a citizen, was not received by the state there as a president, but as an individual. So if the president then wants to initiate such a process as a citizen, he must of all do exactly that. Announce to us that this is not the president doing this, it is me as a citizen. I see my time is running out. I have my colleagues to submit on a few issues. I submit that the appeals before you are not merited. The same should be dismissed. The court ought to uphold the judgment of the Superior Court. I'll invite my learned friend, Carol Gerono, to just address on a few issues. Thank you, my lord.
Thank you, Mr. Mutuma. Please introduce yourself, and I hope you know you have like 10 minutes. Because we'll adjourn at 1:30.
My lord, we had, my name is Miss Caroline Gerono. I appear alongside Mr. Mutuma and Professor Kindiki for the 19th, 20th, and 21st respondents.
With your permission, my lord, could I seek a clarification? This court gave directives earlier on that each of the respondents will have 2 hours, and put a caveat that there should be no repetition. My lord and ladies, this matter is so monumental. I want to plead with you, even as my colleague finishes her time, that you allow us to do our 2 hours. There will be 0 repetition, and I believe will be of help to the court. And so, my lord, I did a directive so that you can guide us as we go for lunch.
Are you talking of, Professor Kindiki, are you talking of 2 hours over and above what has been taken by your other 2 colleagues?
No, my lord, 2 hours cumulatively. I know we will be spending 1 hour by the time we go on recess, on adjournment. So I'm kindly requesting with tremendous humility if we could have the extra 1 hour after lunch.
1 more hour?
Yes, my lord.
Ms. Gerono,
Yes,
would you, in the remaining 9 minutes, have finished your bit?
No, my lord. We had apportioned ourselves that I would do 30 minutes. So I would suggest to the court if we would adjourn for lunch, then we have 1 hour uninterrupted shared between me and between Professor Kindiki and myself.
Can we give Caroline Cherono like 15 minutes and Professor Kindiki 30 minutes, a total of 45 minutes? We can adjourn now so that you are able to, put your thoughts better. We'll try to accommodate with the request that you have made.
Sorry to come back on this, my lord, but the appellants each had 2 uninterrupted hours, and they will also have a bite at the cherry because of the right to reply. it is only fair, my Lord, that you consider giving us, as a team, 2 hours, and how we share it, we can leave it to the internal mechanism.
Okay, then let us do this. Let us adjourn now, and when we come back, we will see what happens. We hear what you've said, Council. After 1 hour precisely. Hope. Who appears for 254? Dr. Ebos. Yes. Dr. Eboso, you have the cross appeal. Okay. Then there is E426 of 2020, Isaac Oluchier. You're appearing for yourself. Okay. And there was petition number 2 of 2021, which was initially in Mombasa, Muhuri, mostly for human rights. Who is appearing for Muhuri? Sorry? Kituku. Okay. And that is Dudley? You appear for who? Dr. Jack Wemali. Was he a petitioner in the High Court? Sorry? He was amicus. So amicus, we have told them to put in their submissions, and I believe they have. Then there was E397 of 2020, where there was David D, Gerald Sei, James Gondi, Wanjiro Gekonyo, and Carl Angelei. I believe Mr. Harvey and team, you appear for them. And you've already done your case. Now, in the morning, sorry? Yes. Just check whether the microphone is on.
May it please, my lords, Martha Karua with Muthoni Nyuguto for 3 Amishi. That is Jack. Let me read from the whatever. Dr. Duncan Ojwang, Linda Musumba, and Dr. Ambani. And my lord, we are not here as Amishi. We were Amishi in the Superior Court, in the High Court. But here we have been brought in as respondents by the appellants and we have responded as respondents. So we are sitting here expecting to get our time, and a lot of allegations have been made against the Amishi and their submissions in the High Court. So we are sitting here expecting to get time to respond, and we have already put in our submissions as respondents because we were dragged here as respondents.
Even when we were Amishi?
We would have come as such, but we were brought as respondents by the appellants.
By the appellants.
Some of whom now question how we are here after bringing us. So we are here ready to argue our case.
Okay, and you would require how long?
We will try, because we are coming after many, we will try our best to compress, not to repeat. But nobody so far, other than accusing the Amishi, nobody so far has put across our points. Yeah.
Okay. Let us see.
Lord, may I?
Sorry?
Ochiel Dudley.
Yes.
I join in that issue with senior counsel. We are sued as respondents, and quite serious allegations have been made against us.
Ochiel, you say you represent one who?
I represent Dr. Jack Mwimali.
Jack Mwimali.
The 14th respondent, a former amicus. My Lord, serious allegations have been made, as a result of which the court even had to admit other amicus because there was a claim that we were not neutral. So we'll request to be heard orally. Thank you, my Lord.
All right. Mr. Kindiki and Professor Kindiki, rather, and team, we had agreed that when we resume, Caroline Cherono, you are there. How many minutes are you going to take?
At most 20.
At most 20. And Professor Kindiki?
My Lord, with your kind permission.
You say 40 minutes. We are just taking the indication, and then we will see what time to allocate.
May it please you with your permission, my Lord?
Just 1 minute. So we will have finished with Third Way Alliance, Meruru Wareru, and Angela Mikali in E200.
E400, my
yes,
Lord.
Yes. And then Mr. Ongoya, can you do it 30 minutes? Yes. What time do you think is reasonable for you, considering that those who have gone ahead of you have covered most of the issues or some of the issues? Miss Kituku, if you can hear us, you appear from Muhuri. Somebody says she's appearing virtually. Okay.
My Lord, with your kind permission, my name is John Mwariri from Kituo cha Sheria. I would wish to echo the request by Honorable Karua that we'll be requesting for 40 minutes. We are led by Dr. Haminwa, both for Kituo cha Sheria and Kenya Human Rights Commission. So our humble request is that you give us 40 minutes for our submissions. That is both for Kituo cha Sheria and Kenya Human Rights Commission.
My lords, my ladies, my name is Devanjiru. I'm just asking probably for clarification. Because when we were granted our opportunity to make submissions before you, we were at least constrained of time, just like, and we were respondents. What happens to the equality of arms? Shall we be granted an opportunity then to do a rejoin of their submissions so that then there can be equality of arms? They are all respondents deserving equal treatment.
My Lord, with your kind permission,
My name is Awele. I appear alongside Senior Counsel Otiende Amolo and James Orengo. I'd like to just pitch in from where my learned friend has left. My learned senior, Martha Karua, has intimated that they were dragged to this court as respondents. Speaking on behalf of the second and third appellants, we sued, or rather we filed this appeal and cited the amicus as amici. And even if they were cited as respondents, it was not by choice. It was on compliance with procedural guidelines of this court. The Court of Appeal rules provide that any person who is served with a notice of appeal shall file their notice of address of service as respondents. And so the mere characterization of them as respondents cannot give them the right to then come and substantively take an adversarial position from that which they took at the High Court. We are asking, ordinarily we would not be objecting to amici making presentations. But if the court is going to restrain one amici, or one amicus rather, from making oral submissions before it, I think it is only fair that the court applies the same standard on all amici, because they did not make any substantive pleadings at the High Court or prayers that would warrant them now taking an adversarial position in this appeal. And so I think, even just for the management of time, I think it would be in order if the court were to stamp its authority. Their submissions are quite lengthy. We do not agree with the adversarial position they've taken, but we will deal with them in our submissions. But for purposes of equality of arms, let all amici be treated equally. Most obliged.
If the court allows me to respond to Mr.
Just Senior Counsel, before you respond, just hold on. Is there any other party that had filed a petition and I have not called them? Respondent. Is there a respondent who had filed a petition? All right, because I say there were 8 and that was consolidated. Okay. Now, Senior Counsel, what are you saying? I have basically taken time indications. We haven't allocated time. We are going to make a decision because we must manage time in such a way that we finalize this matter by tomorrow 4:30.
Yeah, I will not take the court's time. I just want to draw the court's attention that in the Memorandum of Appeal, Volume 1 by the AG, Ground of Appeal number 6 is devoted to the amicus, and in fact we are being referred to as purported amicus. So it's really adversarial, and it is in that capacity we have responded.
Okay, we may give you some time to respond, but it will not be the 1.5 hours that you're talking about. We will see how much time to give you, because we agree that there is a specific allegation made about or against your client as amici. Now, just You all heard what my brother Justice Kiage said. We will have to accommodate one another insofar as this time allotment is concerned. The parties who wanted to file submissions have put in very good submissions, all of you. And so if we were to allocate at most 1 hour or so, we think it will be possible to accommodate the main parties and Amishe, other than thus the ones who say were specifically referred to, will give you much shorter time to respond to those issues. And when you get to the podium, please just highlight your submissions. Now, Caroline Chirono, can you take the podium?
Thank you, my Lord.
Let me have your submissions, please. Please carry on.
For purposes of record, my name is Caroline Gerono. I appear for the 19th, 20th, and 21st respondents. My Lord, my learned friend, Mr. Mutuma, has taken the court through the process termed popular initiative as it ought to be, and how the appellants, or how the impugned Constitution of Kenya Amendments Bill 2020 was processed. I'll take the court, or my submission rather, is on the part of public participation with respect to the Constitution of Kenya Amendments Bill 2020. My Lord and my ladies, I will begin by drawing the court's attention to our Bundle of Authorities, Volume 2, that is dated 23rd of June 2021, at page 558, that is Raila Odinga. Sorry, Honor, just a minute. That is paragraph, page 668, Raila Amolo Odinga in another versus IEBC and 2 others. The learned judges of the Supreme Court, while nullifying the presidential elections of 2017,
yes,
stated that, while relying on authorities as stated in that authority, that election is a process. It is not a one-day event. I will not belabor the court because we have filed the authorities and the court can revisit later. And the appellants have indeed confirmed to this honorable court that referendum is an election process, is an equally a process as opposed to an event. And because it is a process, then there are parameters that have to be complied with. We submit, my lords and my ladies, that even if the promoters of the 2020 Amendments Bill had rightfully started the process, I'm avoiding the term initiated, in consideration of Article 257(1) of the Constitution, then there was complete violation of Article 10 and Article 33 of the Constitution. My lords and my ladies, I draw the attention of the court to our authority found in our Bundle of Authorities, Volume 2, at page 558, that is Republic versus IEBC, Expansion National Super Alliance, NASA, and 6 others. The court, as paragraph 160 in that judgment, held that the people of Kenya did not intend that these provisions be merely suggestions, superfluous or ornamental. They did not intend to include these provisions as lofty aspirations. Kenyans intended that the said provisions should have substantive bite and that they will be enforced and implemented. My lords and my ladies, we demonstrated in the High Court chronologically how the promoters of the 2020 Amendment Bill abrogated the provisions of Article 10. And we submit here today that they have not even attempted to tell the court if at all they did comply. My lords and my ladies, Learned Senior Lucy Kambuni told the court that a promoter would appeal to people whom they deem that they would be moved or convinced by the proposal in the process of collecting signatures. That means there is a possibility that a promoter of an amendment would go to a particular place, call upon his or her friends, or even pay them, whichever manner, collect the signatures, it doesn't matter, leaving out all the other counties, leaving out the common Mwananchi, who is in Kakuma, who is in Homa Bay, who is in Tana River. The promoters have told this court, or the appellants rather, have told this court that a popular initiative only becomes so at the point of signature collection. My learned friend, Mr. Mutuma, has demonstrated to this court that changes to a constitution by amendment does not begin at the collection of signatures. It begins from the enactment stage. We demonstrate to this court that the bill, the Constitution of Kenya Amendment Bill 2020, I would call the impugned bill, was not prepared in such a manner. It does not comply with Article 10 of the Constitution. There was no public participation. And I demonstrate this way, my lords and my ladies, that the motive of the promoters, as it has been submitted, that it is the executive, the motive, the intention was not presented to the people of Kenya. The first Gazette notice was all about policy issues. The second Gazette notice number 264, which is dated 10th January 2020, includes statutory changes. The recommendation, the terms of reference include statutory changes and constitutional changes. The appellants have not belabored themselves to demonstrate to this court that indeed, when the steering committee went round as they purport to have done, did they present to the people of Kenya that we want to change the constitution? What do you say about this article? What do you say about this clause? Were the people of Kenya informed? Our answer is no. The Kenyan people were not made known of the intentions of the executive as it has been demonstrated. If the court so finds that indeed the executive is allowed or permitted by law to carry out changes or amendment to the Constitution under Article 257, did they make it known to the people of Kenya that there is an intention to change the Constitution? I will refer the court, and I see my time is running, to what my learned senior has referred to, the supporting affidavit of Miruru Waweru that is found in Volume 4 of Record of Appeal of the Attorney General, the forward by the BBI Steering Committee to the President. They told the court that the Steering Committee held 93 stakeholder meetings. Where were they held? KICC, Laiko Regency, and the offices in Nairobi. My lords and my ladies, this country comprises of people living in 47 counties. The stakeholder meetings were carried out purely in Nairobi. At the point of effecting service upon then the first and second respondents, that is BBI Steering Committee and the BBI National Secretariat, we had a challenge. We had to serve their advocate. That means the offices were not even known to us. What about a common mwananchi? On that account alone, my Lord, I pray that, or I submit that, the High Court was right in holding that there was no proper public participation. I refer the court to the authorities that we have cited, and more specifically, the county government of Kiambu versus Robert Gakuru. It is found in Volume 1, sorry. Volume 1 of our bundle of authorities at page 125. And your ladyship, Honorable Lady Justice Nambuye, together with the team, upheld the judgment of Honorable Justice Odunga in that there was no public participation in the process of enacting Kiambu Finance Act, and the entire process was nullified on account of lack of public participation. And the courts, both in the Superior Court and in the Appellate Court in this case, made reference to the famous Doctors for Life case, which we have relied on in our written submissions, both at the High Court and before this Honorable Court, and it is in our bundle of authorities, Volume 1, as well as in the judgment of the Superior Court, on the emphasis on public participation. That when there is no public participation, any legislation that suffices is invalid by virtue of lack of public participation. My lords and my ladies, I draw your attention to paragraph 22 of that authority, where the court, relying on Doctors for Life case, stated that the bottom line is that public participation must include and be seen to include the dissemination of information, invitation to participation in the process, and consultation on legislation. We submit that this was not adhered to. My lords and my ladies,
yes.
Sorry, my lord. My lords and my ladies, if we get now to the collection of 1 million signatures, as per Article 157(4) of the Constitution, we have laid our basis that at the point of enactment, at the point of formulation of the amendment, the questions to be posed at the referendum, in the event that it would end in a referendum, Wanziko was not involved. Wanziko was never invited. It was an executive affair. At the point of signature collection, were the people of Kenya involved? We submit that they were not. And the appellants have told this court, in their own admission, that the role of Wanjiku is preserved for a referendum. That public participation, it was premature to carry out public participation before the referendum is rolled out. We submit that. In a situation, in a scenario, my lords and my ladies, where when the bill lands at the president, and the president deems fit that none of the suggested amendments fall under Article 255(1), and so it does not need to go to a referendum. At what point will the views of the Kenyans be absorbed or be incorporated if at the initial stages they were not incorporated? Because prior to the bill getting to the county assemblies, prior to the bill getting to parliament, there is still a window for the Kenyans to make their suggestions as to whether they agree or not on certain elements, on certain suggestions. But once IEBC presents that bill or those referendum questions, suggestions to the county assemblies, as it is, any public participation undertaken thereafter is inconsequential. So we submit that by closing that chapter and telling the people of Kenya that you wait, referendum is on the way, that is when you will express your views. That is an absolute violation of Article 1 on the sovereignty of the people of Kenya. My lords and my ladies, see my time is up. But I would want to peg the question to the IEBC. IEBC have submitted to this court that their hands are tied. Their duty, their obligation was to only verify, just confirm if the initiative is supported by 1 million registered voters. Article 1888, sub-article 4G of the Constitution gives IEBC the mandate to carry out voter education. What does voter education mean? In election, in a general election, for example, IEBC would conduct civic education to sensitize Kenyans on how to vote, the colors that they are going to use, a kind of demo on how the actual election would be. In this context, why would IEBC give a template to the promoters on how to collect signatures and fail to dispense its constitutional duty to tell the registered voters of this country that, look here, something is coming, and this thing is going to affect your day-to-day lives? Because if it is approved, it becomes part and parcel of the Constitution, and it will affect every other Kenyan. IEBC would have carried out voter education, tell the people of Kenya how to append their signatures and what they are appending their signatures to. That way, there would have been public participation. In this context, it did not happen. We are told that IEBC, having received so many million signatures, verified it as they call it, and cast it on their website. My lords and my ladies, it baffles me that the Attorney General says that in the event, sorry to digress, but I'll come back to it. In the event that this bill goes for a referendum and that the judges having held that there should be multiple questions as opposed to binary questions, then at paragraph 150 of their submissions, the Attorney General's submissions, that it would disenfranchise Kenyans. That this country consists of 7.8 million adults, illiterate adults. Why would it be that it would disenfranchise Kenyans at referendum and not now when they are endorsing a document that they have not read? We submit that there was no public participation from the initial stage to the collection of signatures and even to the county assembly level, where we gave an example of Siaya County. We gave an example of, there is a case which we have cited, that is Tana River case. I will not refer to it because my time is up, where the court nullified the process, and I pray that this court will have a look at that case and how maybe going forward on the jurisprudence of that case.
What did you call it? Siaya case?
Sorry?
You say Tana River County?
Yes, it's a Tana River County case. You will forgive me because my time is up.
No, if it's in your bundle, we'll look at it.
Yes, it's in our bundle of authorities. I submit, therefore, my lords and my ladies, that on the account of violation of Article 10 and Article 33 of the Constitution, that the court rightfully made its findings and that this honorable court so upholds. I rest my case.
Just before you go,
yes.
The Siaya County you just told us about.
Sorry?
Siaya County,
yes,
and Tana River.
Yes.
Was this presented as evidence before the Superior Court?
Yes, my lord, it was.
There was evidence before the Superior Court?
Yes, it was. We had made an affidavit, in fact, an application that gave us a ruling that stopped the president from assenting or from doing anything whatsoever prior to the determination of the petitions as a result of the actions of Siaya County County Assembly.
Thank you very much.
Thank you, my lords and my ladies.
Thank you very much, Council. Who is next?
May it please the courts, my name is Kithure Kindiki. For the 19th, 20th, and 21st respondent. My lords and my ladies, on the 13th of May, 2021, a 5-judge bench of the High Court made a decision which, in our humble view, is one of the most extensively reasoned and groundbreaking decision in the entire history of our country's constitutional jurisprudence. It is that decision that the appellants now ask this honorable court to overturn, citing an array of grounds. My lords, my ladies, we humbly submit that the consolidated appeals be dismissed in their entirety with costs to the respondents, and the decision of the Superior Court be upheld and affirmed for the grounds that we submit herein below. My lords, my ladies, all the appellants view that the so-called Building Bridges initiative was a popular initiative. With tremendous respect, we strongly disagree. Instead, we agree with the Superior Court that this was not a popular initiative. It was rather it was a presidential initiative or executive initiative, which is not provided for in our Constitution, and the attempt subsequently by the initiative's promoters, to rope in the people at the tail end of the process to sanitize their illegal and unconstitutional venture must spectacularly fall on the facts and the evidence. On the issue of the character of a popular initiative, we make two arguments. The first is that we agree with the Superior Court that this illegal process to amend the Constitution of Kenya was initiated by the President of the Republic of Kenya in his official rather than private capacity. We say so for these reasons. One, the fingerprints and footprints of the President of the Republic are strewn and splattered all over this heinous affront on the Constitution of our country. My lords, my ladies, secondly, the President created a task force, after which he created a steering committee to implement the recommendations of that task force. And the mandate of that steering committee was clearly stated in paragraph B to include making or proposing legal, administrative, and even constitutional changes. Thirdly, on that point, is that the President established both the task force and the steering committee via the Kenya Gazette. It is our submission, my lords, my ladies, that the Kenya Gazette is not a newsletter, it's not a newspaper, it is not a pamphlet, nor is it a private publication. It is the official publication of the government of the Republic of Kenya, and for that reason, the President, in appointing these institutions, was acting in official capacity, which is our first argument. Further, to cement that argument, the steering committee so established generated a report, and attached to that report was a bill to amend the Constitution, which bill is the subject matter of this litigation. And it is the bill upon which the signatures, which are in contention here, were collected. The fingerprints of the President and his footprints are also evidenced by this, that the submission of the task force report to the President, the submission of the steering committee report to the President, the launch of the collection of signatures exercise, and all other events associated with this ill-fated exercise or process were presided over by the President of the Republic of Kenya using state machinery, and none of these meetings or events took place in anybody's private home. My lords and my ladies, it is our further submission that the reports of the task force on the same point and the report of the steering committee were addressed officially, and I quote, to, open quote, His Excellency, the President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the Honorable Uhuru Kenyatta, comma, CGH, end of quote. Further, it is not controverted that the collection of signatures for this cause was aided to some extent by public officials, chiefs, and other public officials within the executive arm of the executive, which the president presides over. At no point in the whole exercise did the president relinquish his tools of official functions, as was ably cited by my learned friend, Mr. Mutuma, the ESA presidency in 2014, during the International Criminal Court cases. And I am privileged to have been one of the defense counsel in the Kenyan cases at the International Criminal Court. And when it came to the hearing of that court and the initial appearance, the president of the country downed the tools of power openly and publicly and signed a deed, in which deed he appointed his deputy for approximately 60 hours or thereabout to act as president of the country so that he could attend to what he termed a private and personal matter as a private citizen, Mr. Uhuru Muigai Kenyatta. My lords and my ladies, on the second argument on that point, we submit the President of the Republic of Kenya has no right to initiate a popular initiative. Why? Because this avenue of popular initiative is reserved for private citizens, including civil society, and is not available to state officers or state organs. The learned judges in the Superior Court took time to explain that the historical context of Article 257 on popular initiative, according to the Bomas report, was the history, the checkered history of Kenya with constitutional amendments. And therefore, it was clear that citizens wanted an avenue where they can amend the constitution and force government to legislate things that they think government through the organs of state does not wish or is not ready to legislate. How then can the same government, which is supposed to be compelled to legislate by the people through a popular initiative, be the same government using that avenue? And therefore, we agree with the learned judges of the Superior Court that there were other avenues available to the head of state and the president to initiate whatever amendments he wanted to do. First, under Article 132 of the Constitution, the cabinet may make proposals to, for legislative proposals, the cabinet can do that. Also, the Attorney General under Article 156 of the Constitution normally aids the President in bringing government legislation. And under this Constitution, particularly, the office of the Leader of Majority in the National Assembly and the Leader of Majority in the Senate is actually the avenue through which government bills and legislation proposals are channeled. And I speak that with some little authority by virtue of my previous background outside the premises of what we are dealing with today. That therefore this was the wrong avenue for the president to use, and he had other avenues to use. Secondly, on the same point, the second reason why we say that this route is not available to the President of the Republic of Kenya is because, as it was found in the Superior Court, that there was no evidence tabled to provide that the President had used other avenues available to him and failed. On the second thematic area of public participation, which my learned colleague Gerono has submitted, I just want to add the following comments. First, I was somewhat surprised when Learned Senior Counsel Otiende Amolo yesterday, or is it the day before, submitted before this court, tried to demonstrate how it is it's impossible for all the steps of public participation identified by the learned judges in the Superior Court for public participation if we are to allow Wanjiku to be the one to drive the popular initiative. We disagree with that view because, and I heard Senior Counsel Otiende Amolo exemplify and ask the court to reflect on whether, for example, Wanjiku can have the bill published, I don't know, in the national languages, the national language, which is Kiswahili, the official languages, which is English and Kiswahili, the vernacular or indigenous languages, and so forth and so on. And he said if we submit Wanjiku to this kind of procedures, it will not have been possible, and I hope I'm not misquoting Learned Senior Counsel. Our view is that this demand, this 10-step process demand, was not the invention of the learned judges in the Superior Court. It is a dictate, a requirement of the Constitution in Article 7 of the Constitution, which the learned judges relied on, which calls on state organs and state processes to, for example, use the languages and even try to promote indigenous languages and the use even of Kenya Sign Language and Braille where possible. And when it comes to the technical side around Braille and Kenya Sign Language, the Constitution is considerate and uses such terms as promote as opposed to demanding outrightly that that must be done. And therefore, on this public participation, it is a demand of the Constitution. Secondly, on the same theme, it is our submission that both the popular initiative and the parliamentary initiative must therefore adhere to what the learned judges provided for the 10 steps of public participation. There was very little public participation in the processes that were taken up to this point before this litigation arose. For example, the example was given of Siaya, which passed the bill upon receipt. Siaya, in their wisdom, the assembly in Siaya County, in their wisdom, decided to pass this bill within 24 hours. I don't know whether they did the public participation at midnight or at 3 a.m. and what methods they applied. Within a day or two, they had passed it. Tana River attempted to do the same, but the county assembly of Tana River was stopped on their tracks, and their action, which had already taken place, was nullified by Chepunyi J, sitting in Garsen, where he said that you cannot submit a bill, a process of enacting such a fundamental bill amending the Constitution and process it in microwave time. In fact, that is the term. You'll see that when you retire in the authority which my learned colleague Gerono cited. It's called Abe, like Abe Shinzo, Abe Brere. Abe Brere, I hope I'm not mispronouncing, Abe Brere versus the Speaker of the County Assembly of Tana River and 2 others. And the judge said, don't even take what you have passed to Senate or even National Assembly. And the thing died. But because the promoters had already had their kill, they had enough majority, so they proceeded, notwithstanding that they didn't have Tana River County Assembly on board. And my Lord, why are we emphasizing this? It's because there is a reason why the Constitution demands that the bill be submitted in Article 257, the bill be submitted to the county assemblies for 90 days. The county assemblies have 90 days to process the bill. There's a reason, and that reason is public participation, among others. I say so because I had also the submissions yesterday by learned counsel, Mr. Gumbo, who told this court that in a different issue of signature verification, the regulations demanded that IEBC should take 14 days. Institution of the state like IEBC to be dragged into this business of hop, step, and jump. Similar to the legend in the Simon Makonde story, where in 7 days, the politicians involved in this process actually must involve the people. We also submit that the appellant's erroneous view that those who signed to support this bill, the 1 million that signed, are presumed to have understood the content of the bill, which is the gravamen of the appeal, part of the gravamen of the appeal by the Honorable Attorney General. This submission cannot stand because, my lords and my ladies, that public participation cannot be presumed. The authorities that we have filed, the Robert Gakuro versus County Government of Kiambu, the Doctors of Life case, and so many other cases, even outside this country, we filed them in our documents. These authorities say that public participation is both qualitative and quantitative. It cannot even be presumed, it has to be real. I think in Doctors of Life, the judges said it has to be real, not illusionary or thereabouts. Therefore, when you see county assemblies, almost all of them, the entire country, passing such a monumental, or rather passing or endorsing such a monumental bill, which is amending not less than 74 parts of our Constitution in a swap.
Who bears the burden? And if I heard the appellant correctly, they seem to say that consistent
proceedings, but they are not criminal matters. So the standard is normally of a lesser, it's on a balance of probabilities. And I think at the superior court level, the issue of public participation, lack of it, was proved to that level, and that's why the judges took a bit of time to agree largely with the appellants, with the petitioners' positions and evidence. I am referred by Mr. Mutuma to page 1663 of our volume 4 of the Record of Appeal. Volume 4 of the Record of Appeal, page 1663, where the issue asked by my Lord, Mr. Justice Tuyot, is answered in the affirmative, particularly the affidavit of Miruru Waweru, paragraph 8, how the county assemblies passed this bill, considered this bill in a lot of haste. Because of my time, my lords and my ladies, we also note that the MCAs, which is a fact, were given a car grant, but that's neither here nor there. That does not mean that they didn't have to follow the Constitution and the timelines given by the Constitution. Our submission is that the timelines given by the Constitution or statute are deliberate. They cannot be played about with or hurry them up, especially when they concern such serious and grave amendments.
The period was reduced from 90 days to how many?
Within 30 days, I think the entire country, except one or two, like in Meru took a little more time, maybe about 40, 45 days, I'm not sure. But the rest of the county assemblies consider this bill in less than 30 days, within 30 days. And that is in our affidavit.
In your view, what was supposed to happen after it's committed to the county assemblies within that 90 days?
Qualitative and quantitative public participation.
Through the county?
In the county, by the county assembly, which of course includes, if you
if you look at it from quantitative and qualitative approaches, that includes time. And for me, they should have taken most of the 90 days to comply with the 90-day deadline, maybe 60 days, 70, 75, 80, or even 90 days. My lords, my ladies, allow me to rush to something which was submitted here by Learned Counsel, Senior Counsel Atiende Amolo, on the JLAC report of Parliament, because he made some remarks that it's not binding. I just want to say that this report is a public document. We also produced it as a result of the directives of this court to adduce additional evidence. We want to simply submit that this report of the Joint Committee of the National Assembly and Senate, the Committee on Legal Justice and Legal Affairs, this report was tabled in the two houses of Parliament, and once tabled, it became the property of the two houses. And it is not true to argue that once it was tabled, because it was not voted on, then it has no evidentiary value. We believe and we submit that both that report and the proceedings, the answered proceedings of the Senate, which reflect the true records, are important evidence, which demonstrates one thing, my lords and my ladies. Simply went ahead and said, but we recommend it be enacted. For example, the issue of Schedule 2 to the report, the JLAC report, which consisted the list of, the issue of additional constituencies. The committee found that there were legal issues that made that schedule inconsistent with the law, and recommended, actually, there was a recommendation even of severing that Schedule 2 from the report. But we want to leave it at that and say that it is not true that these proceedings and these reports are of no probative value. We submit, my lord and my ladies, that I also listened with, and under international law. It's an archaic legal doctrine, originally from international law, but which got infused in national constitutions. But since, especially 1990, the landmark international case of, this is not in our submission, but just we have the court, the Pinochet case. Augusto Pinochet was a former head of state in Chile, and he did what he did for many years and fled and went to Europe. He was arrested, extradited, returned back to Chile, and in that case, because that case took place in the UK, the judges made it very clear, the House of Lords, that it is not the job description of a president to torture and kill people. So immunity cannot be absolute, because those were their charges against Pinochet. And from there, that doctrine is old, and the court should not give any effect to an argument that immunity of the president is immune. The Constitution in itself, the court really guided on that area, is very clear. Does not include commission of international crimes, does not include when the person leaves office, it does not include actions which are not functional. They are not related to the function of the head of state. My lords, my ladies, allow me to say a few things. I know I have 12 minutes on the basic structure. And I'm sorry, my Lord Justice Kiage, I have to do this because the same thing can be attacked from a million sides, and I won't repeat. I hope I won't repeat anything about basic structure. And for me, what arises from all this discussion about basic structure, eternity clauses, and so forth and so on, is whether, my lords and my ladies, there is a hierarchy of norms in our Constitution. That is the question. Is there a hierarchy of norms? We submit that there is a hierarchy of norms. Why? We can even start with Article 255 itself. 255 is saying, my lords and my ladies, 255(1) is saying you can amend the constitution through parliament under 256 or through the people under 256. But there are 10 or so things you cannot, whichever method you're using, you must go back to the people. Paragraph A to J of Article 255(1). That's already a hierarchy. It means you can touch the rest, but you can't touch this one. Second example, in the interest of time. Learned Senior Counsel Professor Githu Muigai, who I consider to be my complete hero on this topic of constitutional amendments by virtue of his PhD thesis, submitted before this court yesterday that the independence constitution had some entrenched, some superior values, but they were removed. But they were returned again at Bomas, and they found their way in the 2010 constitution. So what council, the appellant's council have been telling us is that, oh, the court never said what are these entrenched provisions or basic structure or eternity clauses. And without going into the tautology and phraseology, there is, in my humble view, there is a hierarchy of norms. I'll give you an example, my lords, and some of these questions were even raised from the court, to my great pleasure and satisfaction. If you want to change the Constitution of Kenya and remove the provision that says that Kenya is a democracy, I think it's in Article 4.2 or thereabout. Kenya is a democratic state, multi-party democracy. You want to replace that and say, for argument's sake, that Kenya is a constitutional monarchy. Is that really the same as if you want to change the constitution, Article paragraph 249 on independent commissions, which says that the number of commissioners is between 3 and 11 and 9. Suppose you want to say you lift from 3 to 5 and lift the other side, the ceiling side, from 9 to 11. Will amending that amendment be the same as an amendment that is trying to convert Kenya from a democracy, a multi-party democracy, to a constitutional monarchy? Are they the same? They are not, in our humble view. Second example. If you want to change the territory of Kenya in Article 5 of the Constitution, the territory of Kenya is defined. What the territory of Kenya, what constitutes the territory of Kenya? It is that territory in place on effective date of the Constitution and then split into then the counties. So the territory of Kenya is defined in terms of the whole and the subnational units, the counties. You want to change that and sever some part of Kenya and donate as it used to happen in the old days of international law. If a sovereign was happy with a sovereign of another country, they could donate a part of their land or their space to a neighboring friendly country. That is how Alaska came to be part of United States of America. If you look at the geography of North America, Alaska is somewhere between Canada and United States. Somewhere in between there. Sorry, the other way around. Alaska is beyond Canada. It's after Canada. So you have United States of America, you have Canada, and then you have Alaska. Why? Because it was it was a gift. It was sold to the American president, leader, by the leader of USSR. It was part of USSR across the ocean. So it was sold for $3 million, some 300 or 200 years ago. And so forth and so on. Therefore, we submit with great respect that there is a hierarchy of norms. All norms are not equal. But we secondly submit that the judges of the Superior Court did not say you cannot touch these superior, entrenched, basic foundational provisions. They didn't say so. Instead, they said, you can change, but not this way, not in the ordinary way. You must go back to the people and the people themselves. That brings me to my last submission, because I have 5 minutes, which I will spend now, on my last submission on this area, which was introduced, again, to my great satisfaction and interest, because of my scholarly background, by learned senior counsel James Orengo, on the place of the supremacy of the people, because it's relevant to this. We submit as follows, and I agree with senior counsel James Orengo on this. Elsewhere we've argued this issue, and we are in concurrence about the supremacy and the elevated status of an organ which is not really considered as a constitutional organ, but if you look at it carefully, there is an organ, a constitutional organ called the people. But what I disagree with tremendous respect to my learned senior counsel Orengo is characterization that this organ, in quote, called the people, must exercise their sovereignty within the Constitution. For the following reason, my lords and my ladies, if you look at the preamble of the Constitution, the people are the creator of the Constitution. So the Constitution cannot be superior to the creator. It's a creature of the people. Look at the preamble. I know there is a provision in one of the foundational principles, one of the basic structure principles, I think 2 or 3 there, which says, Article 2 or 3 of the Constitution talks about that the supremacy of the Constitution. It's Article 2. It's Article 2. Yeah? Supremacy of the Constitution, how this Constitution is supreme. But that supremacy ends where the power of the people starts. And that's why the Constitution in the preamble is saying, we the people. Let me just read that. I have 3 minutes. Very important.
Professor, as you do that,
yes,
I understood Senior Counsel Orengo to say that whereas indeed the people are sovereign, the Constitution in express terms says that they shall exercise their sovereignty only in accordance with the Constitution. Those are plain words, black and white.
Which I disagree with, my lord, with great respect.
No, sorry. Are you disagreeing with the words that's how they are written, or you're agreeing with the statement?
I am disagreeing with the notion that the people are bound by their creature. The creator is bound by the product of their creation to do certain things in a certain way.
But can we first of all agree, does the Constitution say that they can only exercise their sovereignty in accordance with the Constitution? So we agree, first of all, we move from text to whether now we agree with the text.
I agree, my lord.
All right, carry on.
Thank you. The reason I argue this is because, unlike my learned senior, James Orengo, who argued that the Constitution is supreme and even the people therefore must act within it, for the reason I have given, that the people are the creator and the Constitution is the creature, the people can even decide to abolish the entire structure here themselves. The people can decide that. And therefore my argument is, yes, the Constitution is supreme, especially the elevated clauses. The Constitution is supreme. But above the Constitution is the people. And I dare submit, above the people is only Almighty God and the blue sky. If you look at the preamble to the Constitution, it says, and I quote as I end my submission, we the people of Kenya, the opening words, that should even send if you're interpreting the Constitution, that should tell you the first sentence, the first phrase in this Constitution, we the people. the Creator, we the people of Kenya, acknowledging the supremacy of the Almighty God, the only supremacy above the people is that of God Almighty. It's in our Constitution. I am not bringing theology here. It's in the Constitution made by the people of Kenya. Therefore, without wasting time, my lords, I believe that above the Constitution is the people. And above the people is only the Almighty God and perhaps the blue sky, because it's also hovering over us as the people. For those reasons, therefore, my lords and my ladies, with tremendous respect, I urge this court to dismiss all the consolidated appeals, the appeals as consolidated in their entirety with cost to the respondents. I also urge this court to find that apparently what we are talking about here was a botched attempt to overthrow the people and their constitution at the same time. Luckily, by the grace of the Almighty, the judiciary, through the Superior Court, came and, in my view, rightfully interpreted this constitution and declared that botched attempt to overthrow the people and their constitution a nullity. Unless there are questions from the bench, I will request my lord and my ladies that I be permitted by the court to resume my seat.
I guess there is none. Thank you very much, Professor Kindiki. Can we have the next respondent?
May it please your lordships and ladyships, my name is Gilbert Nyamweya, instructed by Mr. Morara Omoke to lead his team. Your lordship,
just say for which respondent?
For the 76th respondent. Your ladships and lordships, we come on our knees pleading that if you could enlarge our time, because our petition is the one that raised most of the issues, and every appellant has attacked the findings of the Superior Court that were founded on our petition. Additionally, we filed a cross appeal, so we will actually need time to ventilate our cross petition. We will not be unreasonable.
No, beyond
we just
beyond what time? What you're saying to enlarge beyond what?
45 minutes over and above 1 hour.
I don't know. We will find it difficult, but just deal with the issues as they.
Yes. Your lordship and ladships, let me quickly set out the documents that we filed in opposition to the appeal. We filed grounds of affirmation dated 4th June 2020. We filed a notice of cross appeal dated 4th June 2020. My colleague is informing me that our time has been set wrongly. We are on 30 minutes instead of
I did
perhaps,
not know that. Okay.
Okay.
Now, you set it at 40. Set it at 40. For good reason, Mr. Nyamoya, that yes, you may have raised most of the issues, but they have been covered substantively.
Your lordship, the challenge is that the perspectives that we have towards the issues is a little different from our colleagues.
Can you try to work within that? We will see how far you'll have gone. Please try to work with that.
Number 3, we file written submissions. I believe that you have our latest copy that is more clear. The assistants were informed. Number 4, we file a list and bundle of authorities dated 23rd June 20.
They have been given to us, so please
Yes.
commence. We have them here as a bundle, so please
And
carry on.
we also filed a digest of authorities, supplementary record, and an affidavit.
Put on the time.
I will commence. I will deal with public participation and IEBC quorum. My colleague, Dr. Thiangolu, will deal with the political question and the basic structure. Mr. Murara Moke will deal with mal-choice referenda, registration of voters, presidential immunity, and he will also tackle the cross-appeal. Mr. Topua and Mr. Christian Andole will deal with the popular initiative. Your Lordships, we submit that none of the appellants have made a case to overturn the High Court decision. None of their grounds of appeal can be upheld. I would also like to point out that there are some aspects of the judgment that the appellants have not appealed against. Those we have set out in paragraph 6 of our submissions. Then there is also an attempt by the appellants to ameliorate their appeals, their cases, by changing their positions in the High Court and advancing new arguments. Those we have set out in paragraph 10 of our submissions. On public participation, I will not rehash what has been said. I'll only emphasize on the guidelines that were given by the Supreme Court in the case of British America Tobacco versus the Cabinet Secretary for Health. The guidelines are quite a number, but I'll only deal with about 3. The first one is that public participation, being the touchstone of governance, must be real. It should not be illusory. And applying it to the bill that was the subject of challenge, we submit that you cannot tell people that being their representatives, elected leaders, that you can just present a document to them and require of them to append their consent through signatures, and you have not demonstrated to them what the document is all about. You must give them an opportunity to know what is in the document, and you cannot tell them that, oh, no, you just endorse, you will have an opportunity to participate at the referendum. That is not meaningful. Second, you have to be clear on the subject matter. You cannot have a bill which you tell people that, you know, this is my proposal, support it, and they do not know what is in the bill. You have to let them know what the contents are, and this is to be done through civic education. Again, if you have not published the bill in the languages required under Article 7 of the Constitution, how will they even know the contents? So they will not be clear on the subject of the bill. They will not be clear on what they are endorsing. The Supreme Court also said that civic education is mandatory. The only thing that would matter or would differ is the extent because of the importance of the subject. Now, coming to the importance of the subject, amendment of the Constitution is extremely important. It affects all the facets of life for everyone. You cannot compare it with a sector. If I may use the example of pyrethrum, if you want to develop regulations concerning pyrethrum production, perhaps you will consult a handful of growers, processors, and exporters, whom we know are not so many of them. But when it comes to the Constitution, you must involve everyone. You must ensure that you reach everyone, you give them an opportunity that is reasonable to participate in that process. And that means every Kenyan, whether they are articulate, inarticulate, educated or not educated, whether they are affluent or impoverished, they have to be involved. I would also like to make reference to the submission that was made by the Honorable Attorney General that the bulk of the Kenyan population is illiterate, and it would be nearly impossible to involve them so that they may have a say. We ask you to disregard that submission, because that submission is actually very surprising and disrespectful of our people. When it comes to the question of what are these issues that you are taking to the people to endorse, we submit that you need to separate the issues at the point of signature collection, so that the supporters are endorsing individual issues. You should not give them a corpus of issues and ask them to endorse. They might be disagreeable to some of the proposals. And by giving them an omnibus proposal, you will actually be disenfranchising them. The other subject that we want to talk about in connection with public participation is the notion of political settlements. Political settlements? Settlements, yeah. Settlements that was alluded to by some of the appellants, saying that the Constitution 2020 is a product of political settlements, and people should always cede ground to leaders to determine for them what is good for them. We ask you to disregard that notion and actually discard it. Do not allow it today, do not allow it tomorrow, and even ever to ever prevail, because it will be very dangerous to our democracy. Quickly, I move to the question of the quorum of IEBC. I'll also not reiterate what has been said by other respondents, save to say that, though regrettable that IEBC does not have complete composition and it's not quoted, IEBC itself should not be apologetic about it. It should not be defensive about it. IEBC does not constitute itself. It does not fill vacancies for itself. It is only a victim of circumstances. These vacancies rose not 1 year ago, not 2 years ago. not 3 years ago, but 4 solid years. So why haven't they been filled? I believe that is the kind of dream or novel or movie that Senator Orengo was referring to. This is the one in this whole conundrum. And none of the appellants asked that question. Why are we at this place where we do not have a quorate IEBC?
Yes.
We would also like to point out that IEBC having been left to be in limbo for 4 years, that's a very dangerous position. The country is actually standing on the cliff. Additionally, these 3 commissioners who are in office, even if they may try hard as they may to discharge some of the functions of the commission, are they representative of the face of Kenya? Because we believe and submit that the reason why IEBC was given wide membership is so as to have inclusivity of our people throughout the Republic.
Yes.
As I wind up my part, I would like to leave you with this quotation that was written by Abraham Lincoln. He said, "Stand with anybody when he is right, and part with him when he is wrong." In this particular case, we ask you to stand with the people, because this time round, the people are right, and they do not want their right, inalienable right, to be snatched from them. At this point in time, I invite my colleague, Dr. Thiangodu, to continue from.
Thank you, Mr. Weaver.
My Lord, I request that the order is to run some
Sorry?
project.
Sorry?
I request the court assistant to project something I want to show them. The deed run as a setup. Oh, it's on our screen, my Lord.
Where did it come from?
It's part of my presentation, my Lord. They started my clock, my Lord, before I even introduced myself.
All right. Okay.
My Lord, I've been constrained to fundamentally alter my presentation in view of...
Just introduce yourself first for the sake of the record.
For the record, my Lord, my name is Mudomi Thiankolu, representing...
Is it Dr. or Mudomi Thiankolu?
The actual name, my Lord, is Mudomi Thiankolu.
Okay.
It is an element of vanity to say I'm Dr. So-and-so or Professor so-and-so.
I heard that reference earlier. That's why I wanted to confirm.
Yes, my Lord.
Okay.
Now, my Lord, I only mentioned 2 things in my presentation. One is what I believe should be the overarching questions that should bother you after you listen to all these arguments and counter-arguments. And I suggest those questions are as follows. Number 1, your decision, whichever way it will go, you should ask yourself, what type of precedent will it create? Number 2, what scheme of incentives will your decision either to uphold the High Court or to reverse the judgment set up? Question number 3, which is related, my Lord, is how are future presidents of the Republic of Kenya likely to treat the Constitution if you allow this illegal enterprise and give it judicial imprimatur? how are future politicians and political elites likely to handle our constitution if you reverse the High Court judgment? Of course, my Lord, I don't know the answers to those questions, but there is a court of wise men and women. I truly trust that the court has the capacity to get the correct answers. The other part of the second part, my Lord, and before I go to the second part, there is a small matter that just crossed my mind. There was this story about Wikipedia. I can tell you without fear of contradiction, my Lord, that the definitions in Wikipedia tally with those in the Black's Law Dictionary and those in the Oxford Advanced Learners Dictionary. So it doesn't matter anyway whether the source was Wikipedia. My second limb, my Lord, is what is on our screen, and I would invite our staff to run the slides as I speak. On that screen is a monster, which is an artistic depiction of a creature from Greek legend in antiquity called the Hydra of Lerna. This monster, my Lord, was so virulent, so venomous, that its scent alone could kill from a long distance. It was created by one of the Greek goddesses to annihilate an hero called Heracles. And killing this monster, I don't know why they are not running the other slides, my Lord, was one of the 12 labors of a gentleman called Heracles. The challenge, my Lord, with killing this monster was that it had about 10 heads, and for each decapitated head, it immediately grew 2 extra heads. Now, this gentleman was asked to kill it. My Lord, what I'm trying to say is that the Hydra of Lerna has been roaming our land since the 12th of August, 1897. When this monster came, some of our beloved brothers and sisters, in their wisdom or lack of it, thought it would make a fantastic pet and therefore believed it should be nurtured. Some of our forebearers, of course, did not share that view, and they rose to protest. They include Mekatilili Wamenza, they include Koitalel Arab Samoy, they include Dedan Kimathi, and we could count and count if we had the time, my Lord. To cut a long story, my Lord, this monster ate our freedom. We were colonized. It ate our dignity. It ate our rights. And we were tenants of the crown in our own land, and basically it ate every fabric of our socio, economic, and political identity. We sent our best brains to Lancaster House in London between 1960 and 1963, and their singular task, my Lord, was to design a sword for slaying that monster. That sword, my Lord, was the Independence Constitution. This magical sword was kept under the custody of the judiciary on the understanding that judges sworn to deploy this sword without fear or favor would deploy it whenever the Constitution was threatened with a breach. The people who wanted the Hydra to drive, my Lord, embarked on an enterprise to make the sword ineffective. They were hitting it against a granite rock so that the sword would be blunt 38 times through 38 IPA amendments. At the end of the day, because, my Lord, I'm just brushing through things, given how the court has allocated our time, Kenyans kept running to the judiciary. Kamau Kuria ran to the court saying the monster had swallowed his right to travel and liberty he was told by the courts the passport belonged to the president. Professor Maina Wakenyeti ran to the judiciary to defend his academic freedom, and instead of deploying the sword, the judiciary dropped the sword. I can go on and on, my lord. Anarita Karimi Njeru, Gitobu Imanyara, James Orengo himself, I've seen Dr. Kaminwa. All these people, I could count them until the cows come home. And they kept running to the judiciary, asking the judiciary, please deploy the sword. The monster is about to devour me. And on most of the occasions, because I'm cutting the story, my lord, the various judges, without mentioning their names, invariably trembled and dropped the sword. Before 2010, there were a few judges who, although the sword had been made blunt through hyper amendment, they had the presence of mind and courage to deploy it. One of them was Chief Justice Madan, sitting in that bench called Githunguri versus Republic, with Justice Gishero and with Justice Aganyenye. And they slew that monster, even using the blunt sword. The challenge before you, my lord, because I can't now present as I had intended given the how time has been reallocated, as you ask yourself those questions I began with, Kenyans are watching your decision, not for its intellectual depth, not for its lexicon and how you use the language of the law. What Kenyans are watching is, will the Court of Appeal drop the sword? If you drop the sword, my lords and my ladies, we have been there before. When the courts dropped the sword of the Constitution, we had denial torture chambers, we had detentions without trial, we had sedition laws. It may sound, my lord, like I'm exaggerating, but the whole thing began in small bits. This is an amendment. I beseech you, my lord, and your court, and pray for you and your colleagues, that just like Madan CJ, even nearing his retirement, old and frail, you will have the courage, the presence of mind, fidelity to your oath of office, and that you will deploy the sword and slay this monster, this hydra called the Constitution of Kenya Amendment Bill, the year 2020, otherwise known as BBI. Thank you, my lords.
Thank you, Mr. Siankolu. Counsel, introduce yourself, please. Your time is ticking.
Good afternoon, your lordships and my ladies.
Good afternoon.
Thank you very much for the opportunity you've given us to expedite our case. Despite the short time, I believe that justice will be done. On May...
Just your name first.
Sorry, your lordship. My name is Morara Omoke. Also has been referred to as the 76th respondent and the petitioner in E416, also advocate of the High Court. Your lordships, when the judgment was delivered by the Superior Court, there was an outpouring of joy all across our nation. And there were a number of reasons why our people were celebrating. One of those reasons was the finding of the Superior Court that whenever we have a referendum in our nation, there should be a nationwide voter registration exercise. Secondly, that we must always have a multi-choice referendum. Those are not findings that were not within the Constitution. I will be able to show you in a minute that all those findings are well anchored in the Constitution, and the finding that was made by the Superior Court was merely a restatement of what the Constitution provides. So I will begin with the requirement for voter registration. We have discussed at length multiple cases on public participation. From Gakuru, we've talked about the BAT case. We've talked about all those cases providing the principles, setting the standard for public participation. And that is one of the reasons why we must have a voter registration that is massive, nationwide, before we can conduct a referendum. Because this is an exercise concerning the supreme law of our land. We cannot possibly proceed to amend the Constitution without giving each and every citizen who has a right to vote in that exercise. So I will make reference to articles in the Constitution that provide the principles, the electoral principles of our country. So you look at Article 80. I'll ask you, your lordships, to read Article 81, 82, 83, and 86. And in a summary, you will see that in those articles, the requirement is that the people must be given an opportunity to participate, because that is their political right, number one. They must also be allowed, if they have attained the age of being able to vote, to be registered. The other thing that you will be able to see from those articles is that the only way you're able to participate democratically in that kind of a process is to being able to vote. And you cannot vote when you're not registered. I will quickly show you that since 2017 up to now, we've not registered. Actually, I'm surprised today I was able to learn that it's not even 108, at least from the latest evidence before the court, which was the affidavit that was filed by the IEBC, where they attached a gazette notice, and they showed you that they have registered, as of December 2019, a total number of voters, 19,678,885. That is as of December 2019. Luckily, there's another record, which is a public record, being a gazette notice number 6251, published on June 27th, 2017, before the last election, showing that at that point in time, we had only registered 19,601,502 voters. If you do a quick math, you will see that the number of voters registered, at least in terms of the number, the increment, whether they were voters who passed on, it's merely about 10,000, about 50,000 voters. Your lordships, you should be able to take...
That is between 2017 and 2019.
2019 December, the difference of when I quickly do it by looking, it's merely about 50 to 60,000 voters in a duration of about 3 years. So that tells you that that order that we sought before the Superior Court was well-founded, and it was actually justiciable. So the arguments that that was not justiciable are completely of no legal basis and of no factual basis. At that point is when I get to comment on the burden of proof. The appellants have made many arguments about the burden of proof, and they say that we were not able to discharge our burden of proof. They forgot to tell you that under Section 112 of the Evidence Act, that there are times when that kind of burden can shift to the party who has special knowledge of the subject under consideration. When we were before the Superior Court, the appellants approached the case in a way that I would use the words of the CJ Emeritus, David Maraga. It's like what he used to call utadu, to mean that he was asking, what are you petitioners going to do about it? When we were alleging before the Superior Court that in our country we were not carrying out continuous voter registration, and the apprehension I referred to in the Superior Court that drove me to raise that allegation was the speed at which we were carrying out the amendment to the proposed amendments to the Constitution. The speed which it's really it's at the speed of lightning, and you'll be able to look at all the affidavits presented before the Superior Court in support of the petition E416. There was a supplementary affidavit which was not filed properly by the Attorney General, and I was forced to file it as a supplementary record of appeal. And that one I filed on 23rd of June 2021. I was able to give the entire affidavit I filed as a supplementary before the Superior Court, summarizing all the issues that I had made as allegations in the petition, just to really strengthen the allegations that were made. And I was able to show that the process was moving too quickly, and if we went at that speed, by now we could have had a referendum, was it not for the intervention of the Superior Court, and we would even be here today hearing these petitions. So those allegations I made were more than ripe at that point. But what else can I say about the principle of ripeness? Our Constitution, as we have seen, is one of the most progressive. And when you look at Article 3.1, it has empowered, and the word used is it uses the language. I'm going to read just that clause for the court to take note. So the language uses, every person has an obligation to respect, uphold, and defend the Constitution. You will see that in this particular provision, they did not even say every citizen, they said every person. That means even those who are not Kenyans, who may find themselves within our territory, will be bound by that provision that they must defend the Constitution. What that tells you, my lords and my ladies, is that that argument about ripeness and justiciability has been severely reduced when you come to matters touching on the defense of the Constitution. And that's not the only thing. I refer you to Article 22(1) of the Constitution, again, which says every person has been mandated by the Constitution to defend the Bill of Rights whenever they find that that right has been denied, has been violated, infringed, or denied. They have a responsibility to approach the High Court to enforce the Bill of Rights. That's not the only clause I will refer to at that point. I'll ask you to look at Article 165, at clause number 4, that the High Court is empowered to identify an issue as raising a substantial question. That in this case, we were able to establish the petitions before the Superior Court raised substantial questions of the law, and that is how we ended up before a 5-judge bench. So for the appellants to tell you that there were not issues that were justiciable or ripe, that is a serious misapprehension of the law. So that I've been able to establish the basis for voter registration. There's more that we've said on that subject. I'll invite the court to look at what the Superior Court found, and also what we've stated in our submissions. So I'll refer to the court to look at the findings of the Superior Court at paragraph 764 and to 772, where they summarized our argument before them, and they easily reached a conclusion that voter registration is mandatory if you must maximize the participation of the citizens at the referendum. I'll move quickly to the issue of multi-choice referendum. Again, that one finds strong basis within the Constitution. I'll refer to the same articles I referred to again in Article 80, 81, 82, 83, and 86, which touch on the electoral system, the principles that govern our electoral system. Also, we'll touch on Article 38, political rights. Article 33, freedom of expression. If I'm presented with multiple amendments, how do I choose if I'm told to accept them in a binary referendum question of saying yes or no? And luckily, yesterday when Justice Kiage raised a question about the provisions of Article 257, it came out very clear that within that article, the law simply refers to amendments in the singular. Bills, it refers to a bill. And our Constitution is not a confused document. Whenever it needs to refer to something in the plural, it has always done that. And whenever it needs to say something in the singular, it has done that. That's why we have the President of the Republic, not Presidents of the Republic. That's why we have the Chief Justice of the Republic and the President of the Supreme Court, not Presidents of the Supreme Court. So that point was clearly, I think, very well understood, and I will not belabor that point. The other thing I wanted to explain from the submissions of the Honorable, the Attorney General, suggesting that our people are illiterate, they cannot participate in a referendum. I would like to give it a different perspective, that actually that's a very good admission on the part of the state that our people will require very active, a lot of public civic education before they can participate in a referendum. So that should be treated as an admission that the people are not ready for a referendum. But I'll go ahead and say that actually our people were very brilliant when they made those provisions. And I've highlighted that within our digest of authorities when I've talked about various documents that can guide the court to reach a conclusion that a multi-choice referendum is actually practical, that the people believed in themselves to make the right choice. And the reason I say that, I'll refer you to the preamble of the Constitution, where they say, we the people give unto ourselves and our future generation this Constitution, so they know that they have the capacity to meet each and every aspiration within this document. So within our bundle of authorities, I'll ask you to look at some documents that we presented. One of them was actually considered by the Superior Court, which was a report of the EU Commission on Referendums. And I saw that there was a complaint about it having been written in the United Kingdom. But I'll simply pose a question to those who have found fault with that report. What is wrong with us doing a comparative study, especially with a country where we have borrowed very heavily in terms of our legislation? What is the problem with comparing with that? And when you look at those reports, when you look at a document I gave in the submissions by Wagner, doing empirical study across 100 countries, Your Lordship and my ladies, kindly allow me to just point out to you where to find those documents within the digest, because I think it's very important. So I will ask my ladies, Your Lords, to look at one of the authorities I will ask you to consider very quickly. So the first document is to be found at pages 471 of the list and bundle of authorities. That's volume 1. I filed 4 volumes. It's known as Lessons from International Multi-Option Referendum. That's the article, and it's actually a study by Wagner looking at over 100 countries, gives you data showing that a multi-choice referendum is not impossible, and it's not actually an abnormality. It's something that has been done and can be done, and it's the best way. It's the best way to optimize public participation. I'll ask Your Lordships and my ladies to also consider another report done by the UK Electoral Commission, to be found at page 486 of my bundle of authorities, that gives us a guide, and I think that will be very useful for the IEBC to consider. Kind of gives you a guide on how to design referendum questions.
Just give us the pages. You have said 471, 486, and next.
Your Lordship, let me systematically point out all the documents I've referred to. So the first document I referred to was the one that the Superior Court relied upon, a report of the Independent Commission of Referendums that was published in July 2018, to be found at pages 204 to 427 of the first volume of the 76th Respondents Bundle of Authorities.
Yes.
In summary, in that particular report, I would particularly encourage you to read chapter 8, which discusses this multi-choice referendum concept at length and really affirms the principles I referred to in our constitution. So as I was saying, it's just a restatement of our constitution. The second document I'll ask you to consider is to be found at page 428 to 470 of the first volume again. That is known as Referendums in Europe, an analysis of the legal rules in European states by European Commission for Democracy through law, published in 2005. The third document is the one by Wegner at page 471 to 481. The fourth document, my lords and my ladies, is Guidelines for Constitutional Referendums at National Level, adopted by the Venice Commission at its 47th plenary meeting of 2001. Lastly, a document from the UK Electoral Commission to be found. So the last document from the Venice Commission is at page 482 to 485. The last one is the document prepared by the UK Electoral Commission at page 486, just one page, giving a guideline, and I'll encourage the IEBC to be looking at it as they prepare to implement the finding of the Superior Court. So lastly, because the time is running out, Your Lordship, I'll quickly speak to the cross appeal that was filed by the 76th respondent. It was referred to by our lead counsel, Mr. Nyamweya. So in that particular cross appeal, we are raising a number of issues that we hope the court can consider and make a determination. I'll quickly highlight. I hope Your Lordships and my ladies have that before you.
Yes, we have.
As you can see, we wanted the court, we were praying that the court pronounces itself unequivocally on whether, whenever someone is seeking to amend the Constitution, can utilize public funds. That's one of the issues. In this particular case, we were saying the person behind the BBI initiative was the president himself, and enough evidence has been presented to show that he is the one and none other. And I would quickly add that all others claiming to be the promoters are only agents of the president. They are only now becoming pretenders to the process. Their principle is well known. They are merely agents, and they should not.
There are 8 grounds of cross appeal. You are asking us to determine all of them, eh?
Yes, your Lordships, and my ladies, I ask you to determine all of them. Okay. If it will please the court, I would politely pray that you allow one of our counsels within the team to quickly speak on the issue of public funds. You could give him 5 minutes, your Lordships and my ladies, and there will be one more counsel to come on board to discuss the popular initiative also very briefly. If you can also give them 10 minutes, and you can add me 5 minutes to complete my argument. Is that possible?
No, I don't think so. With respect, Mr. Morara.
Morara.
Yeah, Mr. Morara Omoke.
Morara, your Lordships. Morara, not Mora.
No, I didn't say Mora. I didn't say Mora.
All right.
I said Morara.
All right.
Yes. It is already past 4:30. Precisely almost 20 minutes to 5. We have seen your issues, they're here. So, you can see your time is up. What is your specific request?
So my specific request is you give us 15 minutes, which I'll distribute as follows. I'll give Mr. Topoale Cinco 10 minutes to argue briefly on the popular initiative, and I'll give 5 minutes to Mr. Andole to speak to the issue of public funds. And as you determine that, I will quickly state that there was an issue that has arisen during various questionings by the judges on how the BBI bill became a bill, and I'll quickly propose for you to consider that the final BBI report is what is contemplated in Article 257 as a general suggestion that was converted to the bill.
Just hold on, take a seat.
Thank you, Mr. President.
Now, Council, we will have to stop at this point, and the 15 minutes you have requested for, we shall consider it in the morning. We are aware that you say you haven't finished, but before we rise, we still have a number of parties through their respective council, as we went through earlier before we started the afternoon session, who must address the court tomorrow. And then we have the reply by the appellants, and we have appeal number 307 by Mr. Charles Kanjama. I will therefore say this. While we respect the rights of the remaining parties, including the Amish who were specifically cited to address the court, we want you to request that you consult among yourselves and see how you can best apportion the time, because almost all the issues are cross-cutting, so that one or two of you take a lion's share of the time to just run through all the issues. The others may choose to take like 10 minutes, as we did with some of the respondents yesterday. And for the appellants, I want to ask you to put down your responses in form of the submissions that you are to make, and take no more than 15 minutes to make your respective responses. You are 4 of you. I don't see why each one of you should take 30 minutes. We have to revise the time downwards. Sorry? All right. Council, it is 4:45. We must rise at this juncture.
This conference is no longer being recorded.